Hello, 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 amazing law nerd. It feels like it's been a minute, but it was just graduation, Memorial Day, and now it's June. It's Tuesday, June 2nd. We have a ton to talk about today. We always do. Happy June, happy Pride. I hope y'all are doing well. Let me know in the chat where you're coming in from, what you're drinking. I've got coffee. I've got coffee. It's time to go. Emily, what are we wearing? Our Shapeshift shirt from last year from the Cavaliers. Do we have a show shirt this year? No, they haven't done a show reveal for us just yet. But we have lots to do today. We're going to Utah. I know, Utah. Give me two. We're going to Utah. We have multiple cases to talk about. Well, no. We have multiple Kouri Richins things to talk about in Utah. Not multiple other things, multiple Kouri Richins things. We're going to start with criminal things, then we're going to get to civil things. Judge M has some things to say. I am interested to see what happens when we get to the criminal stuff, because I grabbed it. I haven't read it yet. We're going to go over everything together. One of the things Judge M titled in a way that I was like, well, spoilers, but don't worry, we're gonna get there. For all of you that saw the podcast yesterday, thank you so much for all your love on the podcast. All of you were like, EDB, your hair. Look, there's a whole backstory about a migraine that just like sent me sideways this weekend. It's rare that it happens, but when it does, oh, buddy. So I appreciate all of you that were like, Emily, your hair. I'm like, good. It distracts from the pain pinching my face. As we have the hair down and a hat on, it's perfect as long as it works. It's perfect and I'm here for it. So we are just going to get into all the things. Utah, there is much to talk about. I'm going to roll the intro and I already see questions in the chat that I am going to answer. It's good to see you guys too. Because sometimes it's like 3 seconds and then I'm live. The replay crew always gets like the full, but sometimes it's 5, 10. So if you didn't hear it at the beginning, happy Pride, happy June. I missed you guys too. Nishay, good to see you. Law Nerds, good to see you. I missed y'all. It was needed time off. I missed y'all. It doesn't always feel like rest when there's so much going on. We have some things to talk about in the members only this month. We have some adventures that we need to chat about, and we have some things coming this month that I'm really excited for. So excited. But also, it's been a minute. And so my glasses these are my reading glasses. Look, man, they're not just my stream glasses. They're I can see the print on the screen glasses. We're on the other side of the house. Couldn't find the remote to turn the fan on because it's that time of year where we definitely need a fan. Sometimes it's just that time of day for EDB because we're a woman of a certain age, but the discombobulation is real. And yesterday I got into a project that I could not stop until I was done. You know what I mean? I was like, I am going to figure out how to automate this thing, this like niche thing in my Google Doc. So I was coding, I was coding my Google Doc yesterday. I'm really happy with how it turned out, but it is one of those things where you're like, do I have time for this today? No, but I'm in it. And I have to finish it. Just starting a project when you don't necessarily have time to finish. It was just like, this is getting done today. And then Dr. B's like, hey, remember those plants that you bought? You need to get those in the ground. It rained all day yesterday. The gardening is real. It's just, it's all the things you would expect. Emily, what have we been doing with our time off? Well, we've been hanging out. We've had company at the house. We've replanted the front. I'll share some pictures in the lounge when it is done replanting. I can't wait to see how it evolves over the summer. We've been doing the things. We've been doing the things and trying to just, not worry about all of the packing for college because we had graduation on a Friday. Sunday morning, bright and early, we were up and out to the airport to take T for spring camp and drop him off for this season for Cavaliers. And it was just this and this and this and this and this and this and this. It was so much stuff. It was so much stuff. All right. We'll tell those stories later. We need to get into Kouri Richins documents, but T is off and away and doing well. And we had a good graduation. We were not rained out. It rained. We were inside. And that ended up being an adventure too for all of you that saw the news in Tennessee about the high schools that went ahead with their rain or shine plan and not their move it all indoors plan. We were with the move it all indoors plan, so we did not get drenched. We got wet walking to and from the car, but we did not sit in the driving rain, so that was not without its own peril. All right. Are we ready? We're ready. There are lots of requests for topics. Y'all, I am seeing them. Don't worry. The mods grab them. I see them, but we've got to get to all the things. Is George moping? George is definitely moping. For sure. So he's been but in George's defense, last summer, he kind of moped and took himself off by himself. He's been much more connected to Fred and to us. He has not like gone into isolation. He's been hanging with us. And so that's been good. I think it's going to be good. All right, let's roll the intro. So George, I think George is doing okay. And you know, whenever T calls, he's on speakerphone. And of course, George is giving him the business and gets a moment to be, to meow at him. But he's also been hanging out. So he's been letting us be support, second choice humans, which is the best we can hope for. All right, Law Nerds. Did I already say, let me know where you're coming in from, what you're drinking? Let's roll. We're going to need to go to Utah. We got things to talk about.
Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court.
Look, here is why George is not completely beside himself at us. We got new bird feeders for both the front of the house and the back of the house. So now whatever window George wants to sit in, he can watch the blue jays and the other birds be ridiculous. He can just watch the birds all be ridiculous. So he is very happy with his, wildlife windows here at the house. He has a catio. He's very happy on the catio. He gets to sit out on the catio and watch the birds. Truly, he has just the best day ever. I want to go sit outside on the catio and watch. It is actually a screened in porch. We just call it the catio because they make the best use of it. All right. Are we ready? I'm going to get to a few of our chats. Chloe J93 in the chat said, has something happened with Kouri Richins since the sentencing? Yes, it has. Yes, it has. And chat, I love that all of you are ready to talk birds and feeders. And look, we have been doing some pollinator-friendly landscaping. I have talked about this before. It has worked so well. I have not seen, other than, the wasps of Satan, they're actually red. But I had not seen like big fluffy bumblebees around our house since we've moved here. And we have there are bees and butterflies. It's working. I'm so excited. So we'll talk about it. We'll talk about it another day. I promise. All of the home is my favorite place to be. And I am not road tripping anywhere other than to see band this summer. We're doing all of the things. Sean Carr in the chat, don't worry. The bird feeders get washed more than once a week, and we do not fill them. We have a whole process, but it rains a lot here. So we do not keep the bird feeders very full. So when it rains, they are cleaned and then we clean them out. So they We cycle through them quite a bit. So I'm a homebody anyway, but it's been so fun. It's been so fun. Oh, I love this so much. The Cozy Treehouse says, my 3-year-old has named our big fat bees Frisbee and Friend Bee. I love it so much. It's just, look, it's that time of year. And also for many of us, it's just that time of life. It's that time of life when we're just like, hey, is that a meadowlark? What does my Merlin app say today? I love it. All right. So we have all of the things. Emily, we're the same age, and I was thinking of you as I watched an epic chickadee versus bluebird battle in the backyard over the bluebird house. They do. They really are just, look, here's the thing. Where I live in Middle Tennessee, there are HOAs are a thing. We are not technically allowed to like have chickens or what have you. But no one said that we could not befriend all of the wild birds. Like, I am not going to, well, I might be the reason that like no befriending the wildlife is added. I don't think they can legally do that. But no one said I couldn't befriend the wild chicken-like birds. So, you know, we've just got the wild turkeys rolling around. They're just big chickens at this point. They're lovely. So we're not technically allowed to have chickens, but if the wild birds are just hanging out, there's nothing anyone can do. But where we live, it is almost all HOAs. Finding a house without an HOA is a little more difficult, but that's a topic for a different day. So graduation was great. I shared some pictures on social media and in the lounge. Graduation was lovely. Travis is off and away and in spring camp. Everyone else is off and away in spring camp. I can't wait to start seeing the show reveals. Don't worry. In a week or so, we're going to switch from, you know, what birds are outside of Emily's house to what shows are the Cavaliers and Caroline Crown and Phantom Regiment. And the Blue Coats and the Blue Devils and everyone else whose name starts with blue. We'll be talking about show reveals. Don't worry. We're T-minus like 2 weeks away from talking about band almost exclusively. Don't worry. We'll get there. All right. Irish Princess said, I might have been a member for 3 months, but I have been in the shadows since the days of Murdaugh. Welcome back. Thank you. And yesterday when I was going through my docket, that was the thing I was automating. But when I was going through my docket to kind of update on the cases, I break my docket up into like pretrial, post-trial, and moving Murdaugh back from the post-trial section into the pretrial section was just like, whoa, okay, we got to move. You're getting in. And then I shifted my folders around to Murdaugh trial number 1. I'm not ready. I will keep you in the loop when we see the next Murdaugh court date, because he has not been given a court date yet. So when he gets a court date, I will let you know, because he's back in pretrial land. And then I moved Kouri Richins from, pretrial to post-trial, and Brendan Banfield into post-trial, because I had not updated that. His sentencing is going forward on Friday, by the way. So if you are ready for the Banfield sentencing, that is Friday. I still have cookies. I had cookies for our first International Law Nerd Cookie Day, and I have cookies ready for our second International Law Nerd Cookie Day. I am ready. I am ready for take 2 on International Law Nerd Cookie Day. What I am waiting for is to find out from the court if the hearing on Thursday will, have I checked my email this morning? No, I haven't. We've been getting ready for stream and doing family things. But when I find out if there is going to be televised hearing on Thursday, I will let you know in the app, because we are going to I am going to need to shift a day, because we are streaming Friday. I just don't know which day we're shifting yet. So I will keep you posted in the app and let you know. Hopefully I will know that by end of day, because I am trying to make sure we can cover both. If it's televised, it may not be, but if it is streamed, then I will stream that on Thursday, not stream tomorrow, and then stream Banfield Thursday, Friday. So I will keep you posted in the app. Just make sure you have the Law & Order app, and I'll send out a message at the end of the day. Emily, what does EOD mean to you? I don't know. By the end of the court day Eastern. So I should know I hope I'll know by the end of the court day Eastern. And if I don't know, I'll let you know that I don't know. Now you know. So we will shift our schedule just a little bit so we can cover Banfield sentencing Friday. That's Friday morning. I think, I'm not sure what time. I'll put it in the app this afternoon. I made a note. I put it somewhere. I forgot already. Why? Because I'm so ready to go to Utah and talk about Kouri Richins and the fact that there's still stuff going on. I am so ready to go. I like this better. Wait. Adon, I like this better. EOD means something very different to me. Explosive ordnance disposal. I like that better. I like that better. It's kind of how I feel about Banfield sentencing, honestly. That's really how I feel about the tallest man who ever lived and his temper. So that's where I'm at with Banfield. Let's fly to Utah and give a little bit of a background of where we're at with Kouri and ready to go. Yeah. All right. Let's go to Utah, everybody. Emily, you're not done with your coffee yet. No, I've been talking. We've been talking. All right, let's do a little bit of a background to set the stage for where we're at with Kouri Richins. You'll remember that 100 million years ago, back in March, Kouri Richins was convicted. March 16th, wasn't it? Could it have been the 17th? It could have been St. Patrick's Day. I think it was the 16th. Either way, Kouri Richins was convicted by jury of the murder and attempted murder of her husband, Eric Richins. We saw the sentencing. She was sentenced to life without the possibility of parole by Judge M back in May. I can't believe we're now saying back in May, but back in May. During that period of time, the sentencing was the 13th, Cheryl. The sentencing was May 13th. The conviction was March. And the defense had put over the conviction date, or when she was convicted in March by jury, they had put over the sentencing date till May just to catch up with the judge's schedule. So between the time of her conviction and sentencing, a lot had happened in the civil cases. We've covered some of it, not all. And now we're covering the things that have happened since sentencing in the criminal case. Remember, at sentencing on the criminal case, there was still time put over for a restitution hearing. The prosecution is asking for some things we're used to in restitution, and then also asking to pay back the county. Hey, and that might change depending on what the judge rules in the civil cases. But hey, you still need to pay back the county. And remember that Kouri Richins still has a pending criminal case. And there is a hearing for that. That's just a status hearing. There's a status hearing for that on Friday as well. So if I'm not there, then we will have somebody from Team Baker there and give you an update on what's going on with that sentencing. So sentencing? No, that's the day of Banfield sentencing. What's going on with that status hearing? Because she still has a felony case with 17 different counts in that fraud prosecution. And that's the one that covers stealing her bestie's house. Literally, you stole You stole my fucking house. Stealing her bestie's house, mortgage fraud. Here, let's just put this up on the screen. For those of you that are newer to her case and are like, wait, what second prosecution? There's a whole fraud case. There's a whole fraud case that has not been prosecuted yet because it's been trailing behind the murder case. And now that she's gotten life without the possibility of parole, I don't know how they'll go forward with this because it's not like you can give her more time. So what are they going to sentence her to? Hopefully this case, the biggest part of this case for me is restitution. The biggest part of this case is restitution to Chelsea Barney. But we've got all the mortgage fraud counts. We've got multiple forgery counts related to the mortgage fraud, all of the issuing bad checks because of course, money laundering. It's a lot of counts of money laundering. I remember when we first did this, I counted them up, but counts 18 through 24 are money laundering, communications fraud, pattern of unlawful activity, 26 additional charges for Kouri Richins. Now, when this case was set to trail behind the murder case, the judge appointed the current defense team for the murder case to this case until the end of the murder case. So she's also going to need new lawyers on the fraud case. That has not happened yet. Also, the day after her conviction, I'm pretty sure her conviction was March 16th. So the day after the conviction, remember all of her lawyers. Her lawyers on the civil cases bounced. And when I say civil cases, there is the estate case, the trust case that are probating those two things. Then Kouri sued the trust and estate. The trust and estate sued Kouri, and then like 3 different variations of those. So there's 6 or 7. Damn it. That was not intentional. 6, 7. There were 6 or 7 additional civil cases with regard to the trust and estate of Eric Richins. And the day after Kouri's conviction, the lawyers bounced. And we went through that and we're like, oh, immediately, like the very next day, the lawyers are like, permission to withdraw. We have not seen lawyers in any of those estate-related cases for Kouri Richins. She's also being sued for business transactions, not with regard to the estate. We haven't even gotten into that litigation yet because there are so many additional civil cases. And so in all of those civil cases, the lawyers left. Kouri does not have new counsel in the civil cases regarding the trust and the estate. Yes, 2 separate things. So, in that landscape, Kouri has no lawyers in the civil trust and estate cases. Kouri is going to need new lawyers in the fraud case. In the fraud cases. A lot of litigation has been happening in some of the civil cases, and her lawyers have been doing all of the things, some that we expect, some that we should have expected in the criminal case. So today we're going to start with the criminal case and the litigation that is happening now. Then we're going to go to the civil case and the litigation that has happened since April. So keep in mind that March conviction date, that May sentencing date, and we're going to look at what was happening in between. While we were catching up on other things, Kouri was waiting to see if she would spend the rest of her life in prison and then writing that impact statement from her mom, my opinion, because it just read exactly like Kouri. And her impact statement, not impact statement, her like, I forgive you, Sarah Boone sentencing statement. I think she was busy working on those and not representing herself in these civil litigations, which I'm kind of surprised that we haven't seen her file anything. Because in earlier litigation in the civil cases, we had seen Kouri directly representing herself and writing letters to the judge that she needed more time. But the fact that those lawyers bounced literally the day after she was convicted spoke volumes to me. They were like, deuces. There's not going to be any money here. Yeah, probably. But I don't know why anybody thought that there would be, given all of these, all of the circumstances here. Oh, and don't forget, if you are newer to the civil cases, don't forget that Kouri also failed to appear at her deposition and actually was sanctioned for it. So there's still sanctions that are pending there. There's still sanctions. There's still sanctions pending there. So let's talk about Kouri. We're going to go, as I said, the criminal case first, and then we're going to the civil cases. The defense filed their notice of appeal. The Supreme Court filed their, hey, this doesn't need to be a direct appeal. We're going to send this to the appellate court. Hey, we're going to appoint appellate counsel, like appellate public defense counsel. So the notice of appeal and those things have already happened in a timely fashion. And what have we learned, everyone, about the courts of appeals? What have we learned? What have we learned about what courts of appeals value above all else? Deadlines. Deadlines. They love a deadline. Just calendar that shit correctly. So they filed their notice of appeal in a timely fashion, which I expected, because of course they did, because it's ridiculous to not to. Clearly doesn't stop it from happening, even though it's ridiculous to not to. So the appellate stuff is ongoing. We saw the notice of appeal. We are going to appeal. The initial briefs and stuff aren't in. That's going to take some time. Don't worry, everybody. You know we are not done once the trial's done. We follow these appeals for years. Hence, Murdaugh and the murdacity of it all. And then the defense filed a motion to embiggen, though they weren't very entertaining with the titling of it. The defense would like to embiggen. Because of course they would. So the defense would like to embiggen their time to file their motion for new trial. Remember, everybody, when we were sitting there at sentencing, and the judge was like, okay, this is the time for motion for new trial. And they were like, but we need an expert. And we're all sitting here going, what the fuck do we need an expert for on the motion for new trial? I have some new thoughts about that based on something I found last night. We'll talk about that. We'll talk about that after this. But we need an expert, and we're meeting with the powers that be to see if we have the money to get an expert for the motion for new trial or whatever. And the judge said, okay, you have, what did he say, 14 days? I'm pretty sure it was 14 days. You have 14 days if you need more time, but you need to tell me why. Tell me why. You need to tell me why. Specifically, you need more time. So they are embiggening and asking for more time. I'm pulling up my note. I'm pulling up my notepad. Things you don't have to worry about with paper. However, I did 2 or 3 trials with paper, and I was like, I can't do this anymore because A, I go through way too much paper, and B, this is just so much. It's just so much easier. So as my notes are pulling up, I believe he said you have 28 days to file your motion for new trial, or 14 days for the extension. I think so too. The Lauren 87, yes, and Vower Tech 28 days extra and 14 days to file the extension. That's what I thought too. So thank you all. You all remember it the same way I did. The judge had extended the time already and then gave them that 14 days to ask for more time. So the sentencing was May 13th. What day was this filed? Let's just skip to the end. This was filed May 27th. All right. Let's see what specifics the defense has for us. And I love that chat is my second brain. Thank you, chat, because got the notes up 100%. 28 days to file it, which was an extension of time, and then file within 14 days to tell me if you need more time, to tell me why. Let's see if this is a motion with reasons or pretty v please, shall we? Because maybe it's just pretty v please. Comes now Kouri Richins and respectfully moves to extend her deadline to file a motion for new trial for an additional 20 days to June 30th, and in support offers the following. Okay. I mean, is the end of June going to be devastating? It's probably annoying, but is the end of June going to be devastating? But Your Honor, I'm out of town. And then co-counsel's out of town. And then we're out of town. So co-SLP said, FFS, it was 14 days exactly. What have we all learned about filing on the very last day? Well, I guess they didn't have to worry about a leap year in the middle of May, but still, it's gonna be May. I'm more curious in the reasons, right? Because this case has been continued and continued and continued and continued. I am big into too much. Trial in this matter commenced February 10th, 2026 with jury selection. It feels like it was yesterday and 117 years ago. This is amazing. SGT Rainicorn. My brain is trying to make that unicorn in 17 different ways. I'm grand marshalling the SLC Pride Parade, Your Honor. Your Honor. Your Honor. Your Honor. I love that and enjoy grand marshalling. Trial in this matter commenced on February 10th, 2026 with jury selection and thereafter began with opening statements and testimony on February 23rd, 2026. The trial continued until a verdict was reached on March 17th, 2026. The jury found Ms. Richins guilty on all counts. Well, then if verdict was the 17th, which it might well have been, and I just forgot that it was on St. Patrick's Day. It may well have been, but then her lawyers in the civil case yeeted the exact same day. Like literally the exact same day, which is wild that they're like, and nope, because I thought it was the 16th. Like I thought it was the evening of the 16th. A lot of you were saying, no, it was the 16th. Okay. Thank you. I appreciate it. Law nerds, thank you for fact checking because the defense has stated this wrong a couple times. I'm literally going back to the video because I was surprised when the verdict came in because it was same day. But yeah, we streamed the verdict on the 16th. So chat's correct. Defense is incorrect. And number of you said, no, the 17th is my birthday. I absolutely would have remembered that. There were multiple of you. All right. The defense still has the day she got convicted wrong. Fine. They're like, it was after the end of the court day, so we just rounded up. What are we doing? Fine. The trial continued until a verdict was reached on March 16th. There we fixed it. The jury found Ms. Richins guilty on all counts. Ms. Richins appeared for sentencing before this court May 13th, 2026. After sentence was pronounced, defense counsel requested an extension of time to file a motion for new trial. The motion for new trial is truly the argument that we saw Ramos making at the close of the prosecution's case. It's basically that again. Why? because the defense didn't put on a case. When the prosecution rested, that was the end of the trial. And Ramos made the arguments then, and there aren't going to be that many more arguments to make. Those are the arguments on motion for new trial. This isn't her direct appeal. Okay. After sentence was pronounced, defense counsel requested an extension of time to file a motion for new trial. The court extended the deadline to file the motion for new trial to June 10th and directed the defense to file a written motion by May 27th if additional time would be needed. From May 13th through May 16th, Ms. Nestor was attending a conference out of state. And do any of you, do we just get to stop work? Like, I didn't realize this was an option when I was at the DA's office, because hey, I've got other stuff to do. They're like, that's adorable. You still have cases that you have to work on. Okay. So how many days is that? You're at a conference out of state in 2026, the year of our internet. There are 2 other defense attorneys, and you're gone for what, 2 days? Like literally 2 nights? Okay. Maybe 3 nights, depending on when she traveled on the 13th. Because that sentencing went all day. Or were you just spiritually at a conference out of state? Emily, that's an Idaho joke. Those jokes can't cross state lines. Yes, they can. On May 20th, Ms. Richins was transported to Utah State Prison and placed on automatic lockdown for 30 days, preventing her from communicating with her attorneys during that time. I can't believe if this is the process and procedure, which I have questions about, but if this is the process and procedure, why didn't they bring it up at the time? Because these are defense attorneys in Utah. It's not like they've never had anyone go to prison before. And these prisons, why didn't we hear them say to the judge, Your Honor, because we've requested this additional time, we know that our defendant is going to be transported. Can you not transport her? Because we will lose communication with her. They didn't bring it up to the court, which makes me think that this either isn't really a thing or that the court is not going to give it much weight because there's no information you need from your client for the motion for new trial because nothing has changed. The motion for new trial is based on the same arguments that you made at the end and the close of the prosecution's case. And this defense team has broken trust and misrepresented so much that I have a difficult time believing that this is 100% the way that this happens. Because lockdown and not able to communicate with your lawyers don't necessarily go hand in hand for me. On May 26th, Ms. Lewis experienced a death in her family. Ms. Lewis, I am sorry for your loss. You and Ms. Nestor have had some very bad luck. On May 26th, Ms. Lewis experienced a death in her family and as a result will be required to travel out of state for funeral services from May 29th through June 2nd. Well, have a good Memorial Day. I'm sorry for your loss. I was in court, and I'm still salty as fuck about this. I was in court the day that one of my closest friends growing up, her mother had passed away. And I went to court that morning and was asking to put over a motion so I could go help. Her father had predeceased. We were barely 30 and she was now in charge of dealing with everything. And I was like, did any of you get blessed growing up with like second parents that were your friends' parents, but like got you? Right. This was one of those bonus parents that just like got me. So lots and lots of love there. I was absolutely devastated. So I go into court. I had a motion that day. I told the defense attorney. The defense attorney's like, this isn't a big deal at all. Take care of what you need to take care of. We'll get to this later. It was a procedural motion. It was nothing that was super time sensitive. It was not a big deal. The defense attorney was so incredibly chill. I was just like, no, life comes first. This is not a big deal. This motion it's fine. So we're talking to the judge. The defense agrees. My supervisor is going to stand in for me so I can take care of my calendar for the next few days, and make sure that my colleagues like have what they need, and I can leave work and go help take care of all of the things you don't even think that you need to take care of that you then all of a sudden need to take care of. So I'm getting ready to leave, and the court calls my office, calls my bosses, and summons me to court. Literally, I said, I have nothing coming up. Whatever next day you need, defense, whatever next day you need, just pick a day that's good for you. I'll make it, it's fine, and we'll argue these motions. Get called in to the courtroom, even though my supervisor was there to pick a new date. And the judge comes off the bench and into my face. And it's like, I don't understand why you can't do this morning. I am puffy from crying. I can't really talk, and I can't really think. And the judge is like, I don't understand why you can't do this today. And I'm like, well, it's a procedural motion. We've all agreed to put it over, and I need to go. And she looks at me and goes, well, it's not like there's anything urgent after the death. And I sat there and went, well, the defense has agreed to a new date. The new date will work for us. This isn't going to delay the court's calendar. And I am not able to argue this today. So if the court is going to force me to submit on my written motion, I think that would be a disservice to the victim in this case, because it was a pretty awful kidnapping case. Like, I think that would be a disservice to the victim in this case. The victim in this case deserves to have this argued. And today I cannot do it. And there is no reason that we have to. And the judge said a few other things that I will not repeat, because then we will never get back to this. But the expectation was that I don't understand what's urgent. Like, I don't understand what the problem is. Why can't you just do it now? What in the world is this? I was moments away from saying, you know what? I'm leaving. You can hold me in contempt. I was so close to just turning around and walking away. I was so close to just turning around and being like, do what you're going to do then. Do what you're going to do then. This judge and I did not get along. Did not get along really well. But you guys know what grief is like. You can't breathe. And so the defense attorney was just like, excuse me, Your Honor, there's no need to do this today. It's actually going to cause some problems if we do. Like, we don't need to do this today. And the defense attorney, just is such a good human, was so uncomfortable in this situation. And I feel so bad for him, because he's standing there as this judge is having a power battle with me. I'm like like there are tears coming down my face, and I'm trying to talk, and the judge is just in my face. Oof. But I say all that to say that I think my perception of what courts expect may be a little bit skewed by some of the courts I had to practice in, because that's where I was at. I asked for, because I think we were coming up on a weekend, I think I was going to be gone for 2 or 3 days. That was it. 2 or 3 days. I was, Anyway, that's the judge. I have lots of stories about this particular judge. This is a judge that I regularly check the news for, and not in a good way. But when I'm looking at, I am so sorry for a passing, I understand. But again, there are 3 defense attorneys on this team. And with there being 3 defense attorneys on this team, others could work. I was eventually allowed to go by that judge. The judge eventually rescheduled it, but I was definitely put through the ringer before the judge allowed that to happen. So I don't understand why traveling out of town for a few days when there are other defense attorneys on the team changes anything. Because again, these are arguments that have already been made. These aren't new arguments. And so that's where I really don't understand some of these arguments. And also, it's just back to back with Nestor being like, I have vacation, I'm out of the country, there's a death in the family, Ramos is in trial. The judge specifically asked this defense team to explain why they needed more time to put into writing the arguments that they've already made. And right now, I do not understand. Right now, all I see is excuses. So, Miss Lewis, I am sorry. Grief is the worst. Grief is the worst. Oh, and then there's the rest of it. On May 26th, Miss Lewis experienced a death in her family. I'm sorry for the loss, Miss Lewis. And Miss Nestor will be traveling out of the country from May 29th through June 11th. The motion for new trial covers several issues that require attachments from the written transcripts, as well as video clips. Okay. These attachments are taking a significant amount of time to prepare in light of the lengthy trial record and the need to edit video clips. What are you using that wasn't in trial? Doesn't your millennial have a Mac or something? Like what are you? This is a motion for new trial based on what happened during trial. What do you, if it was not used during trial, what do you need? Due to the above discussed travel conflicts, the inability to communicate with our client, undersigned counsel do not have sufficient time to complete the motion and attachments by June 10th and will require an additional 20 days. Excuse me, where's the expert? I thought the expert is what we needed more time for. Rule 24B of the Utah Criminal Rules of Procedure says, they say, a motion for new trial shall be made in writing and upon notice. The motion shall be accompanied by affidavits or evidence of the essential facts in support of the motion, If additional time is required to procure affidavits or evidence, the court may postpone the hearing on a motion for such time as it deems reasonable. Your Honor, we're still looking for something that's wrong. We haven't found it yet. We would like more time, which also doesn't really matter because when you are, we just saw this in Murdaugh. When you make a motion for new trial, if new evidence comes to light, then you can make a new motion. Oh, finish mom of three. No, it's no hate to millennials. The defense said it in trial and I was kind of horrified by it. I was poking at the defense some more. I understand why. I was poking at the defense some more. The defense attorney, Nestor, and I think the person Nestor was referring to was actually her daughter or Ramos. I'm not sure which one. And she was just like, Your Honor, we can't. Our millennial has a Mac. She was so flustered about it. So it is me calling back to trial. No. Millennials are exactly like I'm in the Zennial phase, Gen X millennial, but the millennials are right where we need to be. The millennials are like, using their Macs, making sourdough, and trying to breathe through the fact that they continue to live through unprecedented times. The millennials are like, we're fine, we swear. It's all fine. It's fine. Everything's fine. I was definitely not sending strays to the millennials. I was poking at what the defense said during trial. So, watching our birds, exactly. They're busy with the Merlin app, Your Honor. It's Pokemon in real time. Don't make us go back and figure out what the equivalent of Pogs are. We'll figure it out. All right. So we've heard nothing. We've heard absolutely nothing about the expert because the expert is what they needed more time for at trial. Rule 24C of the Utah Rules of Criminal Procedure specifically authorizes this court to extend the time to file a motion for new trial as long as the court does so before the expiration of the time for filing the motion, which is currently set for June 10th. You have to do it by the deadline or it's untimely. Oh, Chloe J in the chat is asking what many are asking in the chat. Has Bloodworth responded? Yes, and we're doing that next. None of the parties will experience any prejudice as a result of the 20-day extension. Well, unless you fuck up the prosecution's vacation, or if the prosecution has other trials, like the prosecution can't do their job until you do yours. So if the prosecution has slotted in time to reply, then it might. Trina in the chat said, why was Kouri placed on immediate lockdown and not allowed to see her lawyers? Trina, two parts. One, there are different procedures when people come into prison. I am not 100% certain that she is on a full lockdown unless she popped off, which would surprise me, unless she popped off and got herself in trouble. But there is normally a integration process where they are separated from other prisoners until all the admin stuff gets done. And then they are moved in where they are not really in lockdown, but they are kept on watch. I imagine that might be a little more extensive after someone is sentenced to life without the possibility of parole. There's an adjustment period. I don't mean there is an adjustment and integration period, but there's also a period where they are watched to make sure that they are not a harm to themselves or others. I do not think, and I have never seen, unless somebody's really in trouble, I have not seen them also not have access to their attorneys. That would be unusual to me, unless they are in trouble. That would be unusual to me. It might take them a day or two to get their communications set up because you have from jail to prison, there's new communication system. It's going to take you a minute to get your iPad thing or your tablet and your new phone account and your new commissary account. Like those things take some time, but I can't imagine that in that time, they have zero access for 30 days to their lawyer. That seems that raises a red flag for me on whether or not that's true. And because we've seen the defense in Biggin, the things that they have shared, I don't know if it's necessarily true. So let's take a look at what Bloodworth had to say about all of this, shall we? Yeah, I can't imagine not having access to your attorney as a matter of course, unless it is just a matter of process where you can't get your phones. But again, the defense would have known that and could have brought that up they would have known around when she would be transferred to prison and what that process looks like. And they didn't bring it up to the court then. So the defense wants more time. I really was hoping that we would see information about whatever expert they are bringing in. But instead, what we saw was a lot of complicated calendaring, Miss Lewis apparently having a death in the family, and, well, needing to edit clips and portions of transcripts for the motion for new trial. So let's see what Bloodworth has to say, shall we? Because I am ready to see the sassy writing of Attorney Bloodworth. At some point, we're going to have to go through, when the record gets unsealed, some of the sealed arguments, because Bloodworth's writing is worth it. Or at least it's worth it to me. I hope it's worth it to you. I hope it's worth it to you. But it's been worth it to me because his Bloodworth's writing is great. We love a little bit of sass. All right. Let's see what the state has to say, shall we? We need a Lippy for this. Yeah, we do. I do agree that video editing can be hard. Here's the thing though. What do they need to edit for a motion for new trial based on what happened in trial? Like, they have not explained what they need. It's incredibly vague. And the court asked them to be more specific. The court said at sentencing, I hear you asking for more time, but I need you to give me more details. Maybe we should go back and watch what the judge said. Emily, are we looking for excuses to see Judge M? I mean, that didn't feel like specificity to me. Maybe we need to go back and watch the end of the sentencing. Magdalena, if you don't mind grabbing, not my video, because we don't need Emily Inception, but our video link for sentencing, so I will go to the end of sentencing and take a look at what the judge said, because I really think he said, I'm going to need a lot more detail about what you want. I'm curious. Let's go to Bloodworth's opposition for the shade. State's opposition to defendant's second motion to extend time to file motion for new trial. Let's not forget, Your Honor, they've already done this once. The state of Utah requests that the court deny the defendant's second motion to extend time to file motion for new trial. The defendant has not set forth sufficient grounds for further extending the time, and the victims deserve as much finality as possible. The court has permitted the defendant 86 days from verdict. I mean, when you put it like that, Again, Brad makes the most obvious point first that I did not make. Maybe then it's not the most obvious. Is that the motion for new trial begins when the trial's done. And in this case, it begins when the state rests. They made their motion to the judge at the end of the state's case. This is an extension of that. So it's an excellent point. Your Honor, it's not our fault they waited to start with their, assignment. It does not begin at sentencing. The court has permitted the defendant 86 days from verdict to move for a new trial, including 28 days from sentencing, which is twice the amount of time allotted by Rule 24. Damn. The reason that timing is short is because it is a standard motion, but also there's no new investigation that needs to be done. Steve, exactly. It's been 86 days. It's been 86 years. It's because they already have the information. The court permitted the defendant 86 days from verdict to move for new trial, including 28 days from sentencing, which is twice the amount of time allotted by Rule 24 of the Utah courts. The amount of time is more than sufficient for 3 well-qualified attorneys to prepare a motion for new trial, notwithstanding the brief unavailability of 2 of them. Contrary to the motion, counsel has full access to the defendant, even though she is locked down. See, that part. That part. It doesn't make any sense to me, even if people don't have full ability of commissary, of meeting with their families, of collegial phone calls. Not having access to counsel is something that these lawyers would have sued the prison system over ages ago if that were true, because that time after trial is busy. You need to do your motions. You need to be able to talk to your client. Bloodworth is just like, this isn't true. There we go. There we go. That. Contrary to the motion, counsel has full access to the defendant even though she is locked down. See State of Utah Department of Corrections Department Manual FD06 Legal Access. See also the Utah Admin Code 251-707. Members of the prosecution team have already scheduled time away based upon calculation of when post-trial litigation would reasonably conclude. If the court grants the motion, the state requests that the court set September 4th as the state's response deadline. Right. Because I imagine, look, scheduling time off as an attorney is difficult anyway. Scheduling time off as a prosecutor when there are cases that have statutory rights to speedy trial and other things takes quite a lot of staggering, especially when you have a smaller prosecutor's office. It's not like there's just unlimited attorneys to fill in. So everyone has to stagger their own vacations, their family's vacations, and then people have life going on in the summer, and they've been in this trial now. It probably feels like a decade for all of them, but this is a substantial trial. It makes sense that they have already set, hey, this will be concluded, and then we're staggering our time off. This makes perfect sense, but also Judge M's going to hate that. Excuse me, Your Honor, September. Ooh, Judge M's going to hate that. Yeah, no. And again, they have 3 defense attorneys from 2 separate law firms. It is not one attorney shouldering the work to do a motion that doesn't really need new information because it's based on what happened at trial. And this isn't the appeal. This isn't writing the appellate brief. This isn't full transcripts need to be in for the appellate brief. Okay. Well, interesting that, but what I found fascinating, and I don't often cover things outside of just what is on the court record, but I saw this snippet yesterday as I was preparing for stream, and I wanted to take a look at an article. And I'm sure there's more about this on Nate Eaton's channel. I have just not had a chance to go and watch his interview with jurors from this case since this case resolved. But we're going to take a look at an article from USA Today real quick because law nerds. I think it gives us a little bit more insight into maybe what the defense is doing. And I just can't, I can't ignore that as we are talking about this and trying to talk about it fulsomely. So let's get dangerous. No, let's get into this article real quick. Why is this being weird? Give me 1 second. Can we just pull up the article, please? USA, can we just, without all of the like auto playing stuff? Okay, thank you. I'm just trying to make it work. Oh, I should have done it the other way. Hold on. We'll do it the other way. I keep forgetting that I had decided to go through a different app to get to the news and that would work better. Let's see if I can do it this way. Thank you, law nerds. Hold, please. Hold, please. Let's see if I can find this article here. You can always tell when Emily's like, oh, wait, no, let's just do this too. When my brain is just like, whoop. Perfect. I'm so excited. All right. Perfect. Found it. So much happier with this result. Thank you, chat, for chatting amongst yourselves. All right. Two jurors from different cases spoke with Nate Eaton at a conference over the weekend. The juror from the Kouri Richins case talked about the impact of sitting as a juror. I hope that Nate Eaton has shared more of that on his channel. I'm sure that he has. I will go look for that after this. I have not looked for that yet, but I'm sure that he has, because he has interviewed these jurors and I think has done great juror interviews. I really like the way Nate Eaton approaches that. So jurors spoke at said conference. We are going to skip over a lot of what they said. If you want to go take a look at these articles, you can. I think them sitting down to have a conversation about the kind of emotional and mental impact of being on a jury is a really important discussion to have. I'm glad they had it. And then if I see that on Nate's channel, I will put it in the description if I find what I am looking for. So that will be here. I am not going to send you to go pay for digital access to said conference. Find it on Nate's channel. So the jurors were talking about one from the Richins case, one from the Vallow case. The Richins juror is one that we have seen interviewed by Nate Eaton before. I think he's a great person to have do these interviews. But what was shared is very interesting to me. This juror shared a lot of things that we'd already seen. I have no idea with the ads, but shared a lot of things that we had already seen in her prior interview with Nate Eaton, talking about the undercover officer's testimony being really important to her, talking about the jurors wanting to look at the evidence and saying, quote, we as a jury wanted to lay eyes on every piece of evidence before we made a decision that impacted somebody for the rest of their lives, talking about the impact that had, but also talking about what has happened since the verdict. The juror said When asked if she had anything to say to Kouri Richins, she responded, "I would have nothing to say to her except we got it right." I love that. I love that. I love that. She said she felt a pit in my stomach the moment the jury handed down the verdict. I can imagine, because it's a weighty thing. And you understand, even though the jurors are not the ones that are responsible for the choices that the defendant has made, it feels incredibly heavy being the one to say, you did this crime. This is what you did. And it's, in this case, I think, different than some others. It's really heavy to say you intended to do this. Because I think in so many criminal cases, people are like, if this was an accident, if this was an accidental OD, it would be tragic, but it would have a different weight to it than your spouse plotting and planning and attempting and then completing a murder against you. They're very, very different things. So I appreciate the juror expressing the heaviness of that and then saying that at the beginning of the panel, replaying the verdict felt like a punch in the gut to her. But what she shared next is what I wanted to highlight. She revealed during the panel that following an interview with journalist Nate Eaton, the defense's private investigator contacted her family and a defense lawyer attempted to have her admit to an error on one of the guilty counts in a phone conversation. What are we doing? What are we doing? This article from USA Today says that they reached out to Kouri Richins' defense lawyers for comment. The jurors didn't make any mistakes in this case. And as much as the defense wants to try to make fetch happen, they're not making fetch happen in this case. And when we saw jurors that had concerns, grave concerns, after the Karen Reed case, what did those jurors do? Tell me, chat, what did those jurors do? Those jurors reached out to the defense. The jurors in the Karen Reed trial 1 were emailing the defense attorneys to tell them what they thought. Jurors in the Murdaugh case agreed to talk to the defense attorneys and tell them what happened. They didn't need to be sought out. And Lawnards, I do not know what the rules are for contact in Utah. In a lot of jurisdictions, lawyers are allowed to contact the jurors. And the jurors can agree not to talk to them, but lawyers are allowed to contact the jurors in a lot of jurisdictions. Lawnards at EDB, have you ever reached out to a juror like that? No, I did not reach out to jurors. If jurors wanted to talk to me, they knew where to find me. I didn't need to reach out to, no. Nope. And I had jurors wait outside of courtrooms to talk to me after trial. I had jurors send me emails. I can tell you what some of those emails were. Hey, Prosecutor Baker, the water bottle that you had every day in trial, I have been trying to find it. Can you let me know what it is? Or, hey, Prosecutor Baker, I really liked the shoes you were wearing during closing argument. Yes, these things happened. Can you tell me what they are? Not like the defense attorney in one of my earlier trials where the jury foreperson went up to the defense attorney after trial and asked her out. And she was like, what? Wait, what? Though a colleague in my office did have a juror reach out to them after trial and ask them out. They're married with kids. So yes, I've had jurors reach out to me after trial. Jurors are allowed to talk to the attorneys after trial. I've had jurors reach out. Did I reply to those questions? I did. They're not allowed to talk to you during trial, but I had jurors wait outside the courtroom to tell me about their experience with the case, because after watching someone in trial, you kind of want to have a chat about the case. And jurors are allowed to do that in California. So, in a lot of jurisdictions, lawyers can reach out. The jurors don't have to speak to them. And it depends if the court has sealed the juror information or if the juror information is available to the attorneys. In a lot of jurisdictions, the juror information is available to the attorneys and they are permitted to reach out. The jurors can say, I'm not talking to you. But yes, they are allowed to reach out in most jurisdictions. Morning Cow said, do you remember what water bottle you were using? I have no idea at this point. Your girl goes through water bottles. Let me just. Cavalier colored coffee mug that I also love. It's also like the soft touch. I love this coffee mug. I had hot water earlier and I couldn't find my other hot water container. I had hot water earlier. Hot water. Laundered water. Other laundered water. Hold on. And mint water. There's a little basil in it too, because the garden's booming. So, if you would like to know what I was using, I have no idea. I have no idea. But this is the typical situation on a given day. So no, I have no idea. So we've got 4 different water containers and 1 for coffee. Right. They're varying temperatures. It's a whole thing. But what's interesting to me is that at the same time the defense is asking for more time, we also, chat, yes, I'm totally a drink goblin. 100%. Monuments of speculation, fizzy water bottle, no, because I have a hard time with fizzy on stream sometimes. And so I try to not do fizzy on stream as much as I can avoid it, because sometimes carbonation and talking a lot doesn't help. So that's where we're at. A lot of you are asking, did the defense do something here that is untoward? In Utah, if it is permissible to contact the jurors, which I imagine that it is, because otherwise getting the juror information would be harder, contacting the juror is not a problem. Now, the way that the juror received that conversation is not ideal. Not ideal at all. Because what do you mean that the juror's takeaway from that conversation was that the defense was trying to have her admit to an error on one of the guilty counts? Now, that part, but we also don't know what happened in that conversation. We also don't know if the defense was like, were there any errors? No? Okay. Also, do I think that any of the defense attorneys would just ask that question and then let it go? No. Because we've seen the way that the defense has talked to the judge. Or the judge saying things to the defense like, that's not true. We saw it at one point, Judge M specifically look at the defense and say, that's not true. I need you to stick to the facts here. Pause. So I worry. But I want much more information about this. I am so curious about what happened in that conversation. I don't love it. Do I think that there's anything specifically improper here? It depends. Do I suspect that there will be some prosecutorial follow-up on that? There could be. Because the prosecution's investigator could reach out and be like, hey, we saw that you said publicly that the defense was trying to do something. Do you want to share that with us? That's if the juror didn't email the prosecution and say, this is what the defense reached out and asked. Because the jurors can do that too. So if one juror is being contacted, I suspect others are. Jurors can talk about this publicly. They're not restricted from talking about the case. And if jurors are uncomfortable with that, they can email the prosecution and be like, hey, this is what was asked. This is what was being said. They can do that. And the prosecution can have their investigator reach out and be like, hey, do you want to tell us about that conversation? But I'm glad the juror talked about it publicly, because then at least everyone knows what's happening. But I'm shocked, but also, are we shocked? Like, are we shocked? So when the defense is asking for more time, am I wondering if the more time is them just trying to find something that doesn't exist? Maybe. Right. But there were problems, right? No. This jury came back in 3 hours. And the juror said, if you had anything to say to Kouri, what would you say? We got it right. That's not a jury that's questioning themselves. That's not a jury that's questioning themselves at all. So let's take a look. If I find more about this, I will share it in the app. I will put it in the description. I did not have time to deep dive this yesterday. As I said, I got stuck in the middle of an automation project coding things. I was really excited about it though, because okay, here's what we did. And then we're going to go look at the clip of what Judge M asked for in this motion from the defense, so we can maybe speculate just a wee bit about what the judge might do given the defense motion we've now seen. But I keep a running docket with dates. I automated making those dates, upcoming dates, into calendar events and the formatting of the calendar event without everything in the document getting scraped into calendar events. And I'm very excited. I'm very excited about it. So when I update court dates in my tracking document, all of it goes on. I mean, Katie, no, it's probably not real coding. It is, EDB using the extensions, scripting the Google Doc. But I'm a normie enough that it feels spicy to me. So it takes just the court dates as formatted and then updates them into the calendar and then links back to the document in the calendar. I'm super excited. I'm super excited about it. So it's just it is scripting. But for me, I feel like I've conquered the world at this point. So excited. So excited about it. Feels like coding to me. I love it. And then they update without duplicating. I love the formatting. So great. It's so great. I'm so excited about it. So it was one of those tasks that annoyed the shit out of me that I'm like, I've updated it here. I got to go update it here. And I'm like, I bet if I just sat down for 2 hours, I could fix this. And so I did. All right. Let's go take a look at the sentencing. Thank you, Miguelina, for grabbing that. Did I plan on doing that today? No. Are we doing it anyway? Yes. Do we want to just say hi to Judge M? I mean, kind of vibes, right? Like vibes. We just kind of want to say hi to Judge M. I think we are actually kind of queued up at the end here. Thank you, Miguelina. That is incredibly helpful. Thank you. And we're going to take a look at the defense asking for more time for their motion for new trial and see what the judge told them he needed and go from there. So let's make sure I'm in the right place. I think so. I think we're pretty close to it. And I appreciate that. I'm going to just back up a little bit to orient myself with where we're at, because I can't see the judge's face. I can only see Kouri's face, which, kind of over it at this point. All right. Let's take a look at what Judge M had to say, because I am very curious. And if we have a little extra Judge M time, it's fine. And then we're going to go to the civil case. But I want to see if this motion meets what Judge M said that he wanted if they needed to ask for more time. Because I just don't remember. And so we're going to just go find out together.
No fines related to any sentence.
We're just going to find out together.
The court addresses the 5 counts on which Ms. Richins was convicted in reverse order.
Okay, that is the sentence being handed down. So I'm going to skip past that.
Concerned about the 14-day deadline, so they...
Okay, and now we're going to back up. I think we're at that motion for new trial. That was just passing down the sentence. Life without parole. We know that. Kouri's face is facing. We know that.
Tragedy that has befallen Eric Richins' sons and family. A person convicted of those things is simply too dangerous to ever be free.
Emily, you had to back it up for the LWAP. I mean, we're right there. I forgot that she rolled her eyes so much at this. Look at the faces facing. Look at all the faces facing. I didn't get to watch the audience last time. She knows at this point in the sentencing, because we're at the very end where he's about to LWAP her. Look at the faces in the background facing.
Family. A person convicted of those things is simply too dangerous to ever be free.
Faces facing.
Accordingly, Ms. Richins, based on your conviction on count 1, first-degree felony aggravated murder, the court hereby sentences you to life without parole. You have the right to an appeal. You must file.
It is such, and throughout this case, it has been such a dichotomy between how Kouri has responded to things and how Kouri Richins has responded to things. And we have seen that time after time after time. And the prosecution highlighted it, I think, really well during closing, where they highlighted how distraught Katie was versus whatever Kouri was doing. And even in this moment of, and I am so glad the courtroom seating just worked out the way that it did. I'm going to move the closed captioning down. I'm glad the courtroom seating worked out the way that it did and that Kouri matches the Kleenex box, because watching it the first time, I was listening to the judge go through what he was going through. I was sitting here going, what is he going to do? What is he going to do? What is he going to do? Now that it's been a few weeks, getting to go back and look at it again, it's really interesting to see all of the different responses to this, but also to see the audience kind of go, oh, is he doing that? With the guys right behind Katie. And then Katie sitting there going, okay, we're okay. And then the defense attorneys as well. We need to do that one more time. All right, one more time. Because there was a lot happening. I'm going to move myself just a little bit.
Accordingly, Ms. Richins, based on your conviction on count 1, first-degree felony aggravated murder, the court hereby sentences you to life without parole. You have the right to an appeal. You must file a notice of appeal within 30 days. You have the right to be represented by counsel on appeal. Mr. Bloodworth, anything further?
Girl.
No, Your Honor.
I think I was so stunned that her entire body roll, like the whole face roll was just like, ugh, ma'am.
Life without parole.
Look at that.
You have the right to an appeal.
Good.
You must file a notice of appeal within 30 days. You have the right to be represented by counsel on appeal. Mr. Bloodworth, anything further? No, Your Honor. Ms. Lewis, Ms. Nestor.
Your Honor, we anticipate filing a motion for a new trial and would like a date set.
And this is the part that I wanted to get to, but the audacity of the responses. The audacity of the responses from Kouri's face. All right. Now we're into the part that I really wanted to hear. The defense asking for the motion for new trial and asking for a date to be set.
We have a substantial record in this case. We will file the notice of appeal of the conviction and the sentence and ask that everything be stayed pending the motion for new trial as we're entitled to do under Rule 4B. Excuse me, but we think we need sufficient time to file a motion for new trial based on the substantial record that exists in this case, longer than the typical 14 days, because this is not only the trial itself, but the years of litigation and motion practice.
86 days. 86 days. You've had 86 days. You've had 86 days.
As that preceded the trial, we were hoping that we could get an agreed deadline of 90 days to file a motion for new trial. Mainly because for half of June I'm out of the country and for half of July Ms. Lewis
I forgot they asked for 90 days.
is out of the country. Normally we would ask for 60, but there's going to be a month in there where both of us aren't available. So we're asking for 90 days.
Right, Mr. Bloodworth.
Your Honor, the state objects. The rule provides for 14 days. I can't imagine this is a decision that was made today. I think counsel's had the last 53 days to prepare the motion, 14 days pursuant to the rule. I appreciate that it's a lengthy record in this case, but the issues available for the trial are fairly narrow. The state
And they're known.
recommends a 14-day time period as provided by the law.
There is one other thing, Your Honor, on that as to why we need the extra.
It's interesting to me the kind of staggered argument of the defense when we get to the pretty please of it all, because it's just, Your Honor, we need 90 days. I'm out of the country. She's out of the country. The prosecution's like, nah, you've had plenty of time. And then it's like, wait, but one more thing, Your Honor, maybe this. It's just like, maybe this, maybe this, maybe this, maybe this.
Time. So we have asked the county to retain an expert to assist to do a declaration for attached to our motion for new trial, and it's going to require us to go before a separate entity to decide whether that funding is approved, and that just takes time. So that's another issue we need.
Not a word about the expert in the motion from today.
I feel like there's more that I need to know in order to make this decision. And so I can also appreciate why a defendant is concerned about the 14-day deadline so they do not lose that opportunity. Sitting here today with very little information and the state having very little opportunity to respond to this idea, I'll extend your deadline to 28 days, but within that time, if you want to file a motion to extend it, Ms. Nestor, with more detail, you have 14.
I will extend the deadline to 28 days. But if you want more time, you need to file a motion within 14 days. A lot of you have questions about the separate entity. The defense, just real quick, the defense is on contract with the county, and there is an entity that approves funding or denies funding for the things they are asking for because they are not operating through like a public defender's office. If they were operating through a public defender's office, assuming that they work in these ways, kind of similar to the prosecution office, if you were asking for additional things, you also need to like submit it to your boss and be like, hey, I need an expert. This isn't what we normally do. Can you approve funding for this type of thing? I mean, there were times that getting a box of pens was just like, fuck it, I'm going to Staples at lunch. But you have to get funding for things kind of outside of your norm. The public defender's office will, of course, have investigators and things like that. But because they are on contract, they need to go ask for more funds. That might have been denied. So it's entirely possible that that might have been denied. Their defense investigator is not a separate expert. They have a defense investigator that was with them throughout trial and sitting behind them with them throughout trial that they'd already gotten funding for. So that is different.
Having very little opportunity to respond to this idea. I'll extend your deadline to 28 days, but within that time, if you want to file a motion to extend it, Ms. Nestor, with more detail, you have 14 days to file that motion.
Did we get more detail? Really, did we get more detail? We got calendar dates, and we got the same argument that they made here. It's just vague overriding. She's on vacation, I'm on vacation. There was the addition of Miss Lewis having a loss in the family, and it was exactly the same that they said in court. There's an extensive record. We need more time. That's what they said. They added in the detail of needing what? Video editing. That's not more detail at all. That's absolutely under pretty v, please.
Not a clarification. So the court
14 days from now, they have an opportunity. They have a deadline to file a motion to extend the 28-day deadline. If they don't, it's 28 days.
Gotcha.
I acknowledge that that 28-day deadline may cause practical difficulties for the state's team, and if I need to extend the state's response deadline, I will certainly give that fair consideration.
Understood.
Ms. Nestor, Ms. Lewis, anything else today?
I understand that this may fuck up everybody's summer because you knew that it was 14 days and then you knew what your deadline is. And now that shifts because when the sentencing date is set, the state can go into their calendar and say, hey, this is the date their motion is due. This is the date our response is due, and block off those days so they have enough time to do the work that they need to do. That calendaring is one of the central parts of lawyering and planning out your time to get things done. And sometimes it really is a juggle of too many things and not enough time. But calendaring is a huge part of this. So, the Bara in the chat said, I'm confused as to what they hope to find by polling jurors. Murdaugh, Karen Reed. They hope to find a needle in a haystack. The Murdaugh situation is so far outside of the norm, but it's explosive. They're hoping to find an anomaly. And I think this defense team has taken a lot of inspo from the Karen Reed case. And at times, I think direct sentences from things Alan Jackson argued. So they're looking for that. And if they don't find it, it feels sometimes like they're trying to make fetch happen to me. I don't think at sentencing notice that Nate Eaton is sitting in the courtroom. I think after sentencing I saw him, I had no idea. But there's so much more I'm noticing on our fifth rewatching.
Ms. Richins, you are hereby committed to the Utah State Prison and remanded to the custody of the Department of Corrections. This court is in recess. Please follow the deputy's instructions. We're off the record.
All right. And that is the end. All right. So we went back and watched what Judge M had to say about the motion for new trial and the extension for motion for new trial. And he's like, I am going to need more detail. I don't think the defense provided much more detail than they did in court when they said, I'm going to be on vacation. Miss Lewis is going to be on vacation. It's an extensive record. We need 90 days. The statute allows 14 days. And the motion for new trial needs to be filed after sentencing. But remember, they had a substantial amount of time between the verdict coming down March 16th and the sentencing happening May 13th. So they had almost 2 full months from verdict to sentencing. And then the court gave them another 28 days, sometimes a full month, after that, when the statute allows for 14. I had forgotten that they had asked for 90. And the prosecution said, look, Your Honor, if you're kicking this out another 20 days, We need this to just happen in September. I don't know what the court's going to do on that. The court has denied a number of motions. So they might deny this motion. And we'll see. It's a good point. Linzer Tort in the chat. This is an excellent point. Didn't Kouri take a paralegal class? Can't she prepare the motion? Can't she assist in her defense? Well, they say they can't talk to her. The prosecution pushes back on that too. So if I said March 13th and inverted my dates, conviction on March 16th, sentencing on May 13th. No, March 16th, May 13th. Potato. We'll fix it in post. It'll be fine. So with that, I guess we'll see what the judge is going to do. I will pull up the docket and keep an eye on it. The prosecution just filed their response. Let me see what day this was. I just grabbed it yesterday, but I think it might have been filed a few days ago. Again, they filed it May 30th. So they just filed this response. But I think that we'll hear from the court. Let me just do that now. And then we're going to move on to the civil stuff. I think that we'll hear from the court somewhat quickly because especially if the court's denying it, it's like, hey, defense, tick-tock on the clock. Like if it needs to be in by June 20th, tick-tock, because it's June. So I can see the court turning this ruling around fairly quickly. Since the docket in Utah can take a little bit of time to populate, I'm going to grab that and let it start populating. And then we'll go to the civil case and then I'll come back to the docket and see if the court has filed anything. Sound good? Good. That's a plan. That's what we're going to do. So, Terry, no, the prosecution responded May 30th. The defense filed theirs on the very last day. So the defense filed theirs on time. The prosecution just responded. So these are all things that are happening pretty much in real time to us. It's not stuff that happened, weeks ago. It's more timely than that. Let me just get this docket pulled up real quick. And while this is doing its thing, we will shift over to the civil stuff. I gave a overview of the civil stuff. Today, we are looking specifically at the estate case because there is a new ruling in that case. But I'm going to back up just a little bit before we get to that ruling and give a little bit more of an overview of what the Richins family has filed. This is Katie acting as the executor of the estate and the trust. They are being probated separately. We are looking at the estate. Remember, Kouri also filed lawsuits against the estate. The estate has sued Kouri to try to claw back monies that were dispensed with, things that properties that were diminished that were supposed to be part of the trust. And so without getting into an entire deep dive in pour over trusts and the estate, my simplest recitation of this is in all of this litigation, they are fighting over what Kouri thinks she's entitled to and what the estate thinks that she diminished, meaning monies that were spent, monies that were moved, properties that were purchased with the home equity line of credit from the house. That money was not supposed to be hers. And then if she bought a subsequent property with it, clawing that back into the trust. So the fight from the estate in total is to pull back in any money that Kouri improperly used. Who is the beneficiary of the estate in total? The boys. All of this goes to the boys. So all of this fighting and all of the legal fees coming out of this diminishes that property for the boys, which is not a criticism of the estate. The estate has to do what they're doing. Kouri is making it more litigation than is necessary by fighting over what she thinks she's entitled to and money that's alleged to have been siphoned off to her mom and to properties and others. So, Silver, we're getting to the ruling. Don't worry. We're getting to the ruling. We're laying a little groundwork. It's not satisfying if we just get to the ruling. We got to lay a little bit of groundwork. Amy Dean asked, wasn't Sky on the civil cases? Sky was on all of the cases until there was a conflict and then was on none of the cases. I think that conflict was within her firm. It happens. Kouri, at this point, lost her lawyers in the civil cases the day after she was convicted. They bounced. Casey Cat said, the state doesn't provide lawyers for civil cases, does it? No, it does not. How is she paying for attorneys? Well, currently she's not. How did she pay for attorneys in the past? Who knows? I have no idea I have no idea what those attorney relationships were, because attorneys can take work on a lot of different ways. Contingency, there's lots of different ways that attorneys can set that up. Or if family is paying, if there was a concern that money had been siphoned off to family and then family was paying it, there's quite a lot of options there, and we just don't know what's inside of that relationship. We do know that the second she was convicted, they made motions to withdraw from all of the civil cases. They were just gone. Lyra asked, isn't Nestor on the David case? No, she is not. That is attorney Blair Burke in California. Nestor is not barred in California, to the best of my knowledge. But no, she is not. She is on one of the many defense attorneys on the Tyler Robinson case, also in Utah. Let's give a little bit of background on the motions that have happened since April in the civil case. I'm going to overview these. We're not going to go line for line. They are extensive motions, but there's some things I just wanted to point out. And in this case, some of these motions go all the way back to the beginning of the case before the stay went into place. In the civil cases, stays were in place while the criminal case was ongoing in different combinations. Just talking about the case governing the estate, we are going to look at what the estate was asking for in April after the conclusion of the criminal trial, right after Kouri bounced. And we saw the motions where they were saying, hey, by the way, you need a new lawyer. And remember, Emily, you're pulling this up purely out of pettiness. Well, yeah, a little bit. Allow me 30 seconds of pettiness. It might be a little more than that. Remember the last time we looked at this ruling from May 14th, 2025, where the court awarded the estate attorney's fees and costs because Kouri bailed on her deposition in these cases. And the court ordered Kouri to pay Katie $8,000, $387.50 back there. So there's also now more was ordered in other cases. This grew. I did an entire stream where we went through all of these orders in all the different cases because this happened in like 3 or 4 different cases. But in the estate case, it was $8,000. It ended up being quite a lot of money over the course of multiple cases. But Kouri was ordered to pay Katie quite a lot of monies in attorney's fees and costs. And the reason the court is referring to everyone by first name is because Katie is Kouri Richins Benson. Kouri is Kouri Richins. We have a lot of people with the initials KR, and it gets real fucking confusing real fast if you refer to people by last name. So everybody just got referred to by first name, and that's why it's a little different than other cases that we've seen, a little less formal. Fast forward to after the verdict. The estate filed 2 motions, and these are motions regarding filings that had been made much earlier in the case that I had covered in other content. So we're going to zoom a little bit. First, motion to lift the stay on the petition to determine a disqualifying homicide. This was filed early on in the estate case after Kouri was arrested, we went over this, talking about what a disqualifying homicide is, not being able to get any money from the estate if you are the cause of death. For more than 2 years, this is the statement of relief requested in grounds. This was filed in April of this year. For more than 2 years, the petition has been on ice while the parties awaited Kouri Richins' criminal murder trial. That trial has now come and gone. On March 16th, 2026, a jury unanimously agreed beyond a reasonable doubt that Kouri murdered decedent Eric Richins. In this case, just a note from me, referred to as decedent, not victim, because this is the estate civil case in probate. All that remains with respect to the murder charge is for the court to sentence Kouri, which happened in the intervening time, after which the murder proceedings, at least at the district court level, will be concluded. Now is the appropriate and necessary time for the court to lift the stay and allow the petition to proceed and permit Katie to move the estate's administration forward. They have not been able to probate the estate because of everything that's going on, including Kouri's own lawsuits. And Kouri's lawsuits have taken up quite a bit of money from the estate, I would imagine, but they also brought us Todd Gabler, which I think is a benefit to all of us. I think Kouri might disagree with the tenacity of Mr. Gabler, but I find him to be absolutely delightful. So when he came in and investigated the estate case, a lot of that's because of how Kouri was fighting this case. All that remains with respect to the murder charge is for the court to sentence Kouri, after which the murder proceedings, at least at the district court level, will be concluded. Now is the appropriate and necessary time for the court to lift the stay, allow the petition to proceed, and permit Katie to move the estate's administration forward. For these and the reasons below, Katie respectfully moves the court to grant the motion to lift the stay on the petition. The petition here is to disqualify Kouri from collecting anything from the estate and to allow this to go forward to probate. I have covered these petitions, so I have this up on the screen for those listening in the background, but I am hopping through it pretty quickly. I love how they summarized it. The petition seeks an order and judgment that 1, Kouri committed a disqualifying homicide. 2, Kouri has forfeited all rights and benefits under Title 75 Utah Code in connection with the estate or trust. 3, if Eric and Kouri owned any property as joint tenants, the joint tenancy is severed. 4, Kouri is deemed to have predeceased Eric. 5, Kouri is deemed to have disclaimed any rights that she may otherwise have under the will or trust agreement. This, without getting too deeply into wills and trusts, this is A, not my specialty. B, I watched movies during this class with my friend TJ in law school. And 3, studied it enough for the bar exam. I am very much in the realm of I know enough to be dangerous, maybe not always enough to be helpful. However, this is a fairly broad overview in Kouri in multiple different ways being disallowed to collect anything. So the legal determination that Kouri predeceased Eric is treating the will and trust as if Kouri had passed, her stuff goes to Eric under the will and trust, and then it gets probated. So these are legal determinations to remove any loophole that allows Kouri to take any money under the probating. So they are going to probate this as if Kouri doesn't exist. Like literally, you're dead to me, but not actually, just literally. So the legal of this treats it as if Kouri doesn't exist. Like truly just, she doesn't go here. So that's what they're asking for in this request to lift the petition. So, Katie, they are not, I know that I appreciate the question. Katie, it's good to see you. Legally dead due to the murder? No, just you don't go here because you committed the murder. And because you committed the murder, this is how the law is treating it. You don't go here. Hopefully that asked. So, Becca has thoughts. Becca, I agree with these thoughts. Becca has thoughts, said, so the lawyers bounce because they know they won't be getting paid. Well, Kouri's being treated as if she doesn't exist in probating the estate. So she's not going to get anything in probating the estate if the court finds that she committed a disqualifying murder. Is anyone thinking that that's not what's going to happen, right? Kouri disqualified herself, exactly. So continuing on with that, we've got the next motion that was filed, which we are not going to go through the entire thing because it is a very, very fulsome 100. Emily's gone full Rick Hogue today. I love it. I'm not nearly as smart, but I do love the word fulsome. This is a 140-page motion for summary judgment. But note what's at the top of this motion. In bold, underlined. This motion requires you to respond. Please see the notice to responding party, Kouri. In addition, please see notice to appear or appoint counsel previously filed. Hey, Kouri. Boo-boo. You need to respond to the motion for summary judgment in some way. Notice! You must respond. This was filed after her attorneys were gone. This was filed in April. Let me look at the exact date for you, and I'll tell you the exact date. This motion requires you to respond. You must respond. I'm going to tell you the exact date this was filed. In April, I think it was April 2nd, but I don't trust my memory on that. Let's see. This was filed. Where is it? There are a lot of exhibits because it's a motion for summary judgment. Remember, motion for summary judgment is what happened in the TikTok psychic case, where the entire case, except for damages, was determined without a trial as a matter of law. This was filed April 2nd. Yay! They're like, it's not April 1st. We filed it April 2nd. It's like when an email says action required. Ace Detective Puff, yes, and I prefer that. Like, I need everyone to start a sentence with, what do you need from me? And then tell me the things. Like, do you need a decision? Do you just need me to listen? Tell me what you need. Do you need me to respond, or is this just an FYI? Just tell me at the beginning so my brain is appropriately calibrated. Because if you just start telling me and then you ask me a question, I'm going to be like, wait, back up. I need more information to answer questions. I thought you were just sharing. Are we just sharing? No. Motion for summary judgment on petition to determine disqualifying homicide. This was filed April 2nd, 2026. Statement of relief requested and grounds. Kouri Richins murdered her husband. That's the beginning of it. Kouri Richins murdered her husband. Emily, do not start talking about Carol Baskin. I'm sorry, my brain just time warped back to like 2020. We don't need that. Kouri Richins murdered her husband, decedent Eric Richins. Unsatisfied with her marriage to Eric, unable to escape from or conceal her ruinous debt, and uninterested in choosing her family over her secret lover, Kouri sought a way out. I mean, damn. And I know there's not a lot of coverage of like estate cases. I don't think we've ever covered a probate case. But the writing deserves a moment, doesn't it? I hope you agree. I mean, you're still here. The writing deserves its own moment. It does. Kouri Richins killed her husband. They go on to say leaving Eric was not an option, because leaving Eric meant leaving his wealth, his assets, and his lifestyle. Kouri wanted, and in fact desperately needed, Eric's wealth. His wealth gave her status. His wealth gave her luxury. but not luxury prisons. I can't help it. I can't help it. I can't help that. Sorry. And she saw his wealth as a potential solution to her calamitous financial woes. I mean, that's a 10 out of 10 sentence. We don't use the word calamitous nearly enough. Attorneys, just well played. Well played. She saw his wealth as a potential solution to her calamitous financial woes. Do you think they're just rubbing it in that Kouri's not a good writer? Gleefully, just like, Kouri can never. She was not about to walk away from status, luxury, or a financial parachute. Yet she was determined to have all of those things without Eric. I mean, we saw that in her emails that we saw in trial, emails that we had not seen before. We saw her talking about, you know, how frustrating it is to be married. Just like, ugh, you have to like consider someone else. It's not yourself. Right. That's what a partnership is. Considering someone else, not just yourself. Yet she was determined to have all of those things without Eric. So Kouri orchestrated and executed an insidious scheme to do away with Eric and thereby transform his wealth into her wealth. She enlisted a convicted criminal, who in turn enlisted another convicted criminal to acquire large quantities of illicit fentanyl for her. With those drugs as her weapon of choice, on or about March 4th, 2022, Kouri poisoned Eric to death in the middle of the night. Or at 9 p.m. and then just sat there and watched him die based on everything we've seen now. With those drugs as her weapon of choice, on or about March 4th, 2022, Kouri poisoned Eric to death in the middle of the night. No sooner had she killed him than Kouri immediately began trying to seize all of Eric's assets for herself. Indeed, less than 3 weeks after Eric's funeral, she had already hired a team of lawyers and launched a scorched earth campaign that targeted everything and everyone standing in the way of Eric's assets. The tea is scorching in this motion for summary judgment. And honestly, I'm here for it. I'm here for it. She targeted Gene Richins, Eric's father. She targeted Eric's business, C&E Stonemasonry. She targeted Eric's business partner, Kouri Wright. Most of all, she targeted Katie, her sister-in-law, and the person who Eric entrusted to administer his estate and the Eric Richins Living Trust. In fact, within weeks of Eric's death, Kouri sued Katie, seeking to overthrow the trust and funnel all trust assets to herself. Yep. For a while, Kouri's campaign of carnage looked promising. Damn, lawyers. I didn't know that estate lawyers had it in them. That's on me. I apologize. I was not aware that this level of sass resided within estate filings. Damn. I am here for all of it. Lindless lady. Hello, EDB. I'm streaming you on the TV in my dentist room. Hello to you and your dentist and the dental assistants and everybody waiting on the doctor to start nitrous for my dental work. Thanks for keeping me company. I'm really nervous. Talk to your dentist. They want to talk to you. Deep breaths. I understand. And sometimes headphones helped because the dental noises were always the thing that stressed me out most. But deep breaths, they're there for you. Let them know if you need to talk through it. But I'm living for the spicy probate attorney because here we are. Well, Kouri's campaign of carnage looked promising. She cashed in on Eric's life insurance policy, lived rent-free in Eric's home, marketed herself as some kind of children's grief author, and miscast Katie as Eric's greedy, conniving sister who was trying to rob Eric's children of house and home. I mean, they're not wrong. But then her campaign came to an abrupt halt. By the spring of 2023, the state of Utah had amassed a mountain of evidence against her, and on May 8th, 2023, authorities obtained a warrant for her arrest. They waited for Kouri outside a title company where she was busy surreptitiously using her quote-unquote best friend's home as collateral for a $95,000 loan. Zara Zabara in the chat said, I apologize. I wasn't familiar with your game. Yes, I was unaware. I was not prepared. But damn, look, when I say there is an order that we need to get to, there is, but also we can't miss this. Like we can't miss this. This deserves its moment beyond just the court and counsel reading it. Because I feel like they were waiting. But until trial, I had no idea that they arrested Kouri outside of the loan company where she was putting another loan on Chelsea Barney's house. The fucking betrayal. Emily, she murdered her spouse. I know. The levels of betrayal to everyone is wild. And that's what caused that decision for Kouri is what caused Chelsea Barney's home to go into foreclosure and for her whole family to be thrown out of the home that they had saved for. So if we're talking about anyone's family getting thrown out on the street, it was Barney's family because of Kouri. As soon as Kouri emerged from the title company, authorities arrested and charged her with aggravated murder, incorrect. The attempt came later, but that's literally a very piddly detail that she was originally not charged with the attempt and it came later, just because I remember being like, damn, what now? Because we followed this case from the bond hearing and the attempted murder wasn't in there yet, but potato, we'll continue. Almost 3 years later, after a 14-day jury trial, a jury of Kouri's peers unanimously convicted her on all counts. Kouri now awaits for this court to impose sentence, after which she will take up a long-term residence in the Utah State Prison. Still living rent-free. Well, not really. Sorry to the taxpayers of Utah. Given Kouri's convictions, Katie seeks summary judgment on the petition. Utah Code Section 75-2-803, or in common parlance, the Slayer statute, not the music, expressly defines aggravated murder as a form of disqualifying homicide. And yes, it's called the Slayer statute in colloquial parlance. Parsnip, parlance. I'm really loving everything about the lawyer's writing here. Emily, you're so easily won over with clever writing. I am. I'm a nerd. I'm here for it. A person who commits a quote-unquote disqualifying homicide forfeits all rights and benefits as an heir or beneficiary of the victim, including an elective share. They lose any joint tenancy interests they may have shared with the victim. That's the house. And she had been fighting over the house, even though I believe that the house was set aside in, my brain is buffering because it's going too many directions too fast. Backing up. Kouri was arguing that the house was not specifically included in the prenup. She was alternatively arguing sort of that the prenup was given to her too close to the time of the wedding. And we had gone over those arguments from Kouri. And there's actually an interesting question there about whether or not the home, because it is not specifically stated in the prenup. However, it was purchased by Eric prior to the marriage And now we know from his sister Katie as his separate property prior to marriage. And so there were some nuanced legal arguments that might have continued to be fought out. However, what this does is say, even if Kouri were to win, even if Kouri was to win on her other lawsuit saying that she had a joint tenancy in this property, they are saying because of the homicide, therefore, even if she wins on the other cases, she cannot benefit. So Kouri could, this is just in theory, Kouri could win the lawsuit against the trust and the estate, saying that she is entitled to a joint tenancy in the home. But they are saying that even if that happens, this disqualifying homicide means that even if she's a joint tenant, she no longer has a joint tenancy. It's severed. So this undoes, I think, all of the other litigation. Because, again, if you murder the victim, you do not get to become a beneficiary of their estate, whether as an heir, as a joint tenant, etc. So then they go on. A person who commits a disqualifying homicide forfeits all rights and benefits as an heir or beneficiary of the victim, including an elective share. They lose any joint tenancy interest they may have shared with the victim. They are legally treated as if they predeceased the victim, and they lose any and all ability to profit from the victim's passing. Period. Done, done, done. You don't go here. Moreover, once convicted, the killer cannot deny the essential allegation of the offense in a subsequent civil action brought against the killer for the criminal conduct underlying the offense. Utah's like, no. Utah's like, take this out of court. Take this out of court. Pesky Pirouette said, Slayer statute, why even go to court? Waste of time and money. Because Kouri sued the estate and kept all of this from being probated. Because Kouri thinks that, I think Kouri thought she was going to win. Northwest said, you are dead to the estate. Yeah. Yep. This is the equivalent of under the prison. Under the prison. Utah's like, no. None of it. But Kouri is the one who has kept this going. And I think that she wanted to stay locked in a fight with the family. The lawyers go on to say that these two statutes, together with the evidence that this court heard during trial, definitively end Kouri's claim status as an heir of the estate or a beneficiary of the trust. She is a convicted killer, and her conviction has both statutory and common law preclusive effect. Katie respectfully requests that the court grant the motion, grant the petition, and determine that Kouri committed a disqualifying homicide. So that is the very fantastic 3-page recitation of Kouri's calamitous carnage. This was 10 out of 10. This was 10 out of 10. There is 140 pages to this motion for summary judgment. But remember, the court has to lift the stay on these motions first. So let's take a look at what was filed by the estate next. Because the estate filed a request to the court on May 5th, 2026. So this is leading up to Kouri's sentencing date. This is after Kouri was convicted, after Kouri's civil attorneys bounced off of everything. Awkward Cali girl, Judge M will preside over this as well. Judge M is the judge assigned to all of these cases. Yes, he is the judge on all of this, which is unique. In Los Angeles, this would be a much bigger mess. because the courts are much more striated. To Be Curious says, is there a non-disqualifying homicide? I guess there could be, because Kouri could have committed a homicide of a third party, like a DUI vehicular homicide, and gone to prison and not be disqualified from the estate. She could have committed an intentional homicide against a third party that isn't the person whose estate she's benefiting from. So there could be homicides committed that are not the death of the person whose estate you're benefiting from. This can come up in a lot of different ways, but yes, that would be a non-disqualifying homicide. I suppose that self-defense, and I didn't research it, I suppose that a homicide in self-defense wouldn't necessarily disqualify you from a state. So yeah, I think there could be circumstances, and I have not researched it in depth. I think there could be circumstances where a homicide is committed that does not disqualify you, but I have not gone all the way in. So that. Continuing on. The estate then asked to submit for decision. What does this mean? Well, Your Honor, we're ready for you to decide. So, the personal representative of the estate requests the court's consideration to the following motions. 1, the motion to lift the stay on the petition to determine disqualifying homicide, and 2, motion for summary judgment to determine disqualifying homicide. The following papers and events pertain to these 2 motions. Stay motion. Katie filed a stay motion on April 2nd, 2026, well, the motion to lift the stay. No party or interested person opposed the motion, and the time to do so has expired. Untimely. 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 The stay motion is ripe for the court's consideration because the stay motion is unopposed. Katie respectfully requests that the court grant the stay motion at its earliest convenience. Disqualifying homicide motion. Katie filed the disqualifying homicide motion on April 2nd, 2026. No interested party or person opposed the motion, and the time to do so has expired. Expired. A disqualifying homicide motion is ripe for the court's consideration because the disqualifying homicide motion is unopposed. Dated this 5th day of May, 2026. So in the month that Kouri was chilling in local custody, there were no responses. The time to respond expired. And I always think of that commercial. I don't even remember what the commercial is for, but I just remember a young couple in the house and their family member, I think their aunt was going through the refrigerator or pantry going, expired, expired, expired. Is it Geico? Thank you. That's what I think of. Expired every single time. The ant problem. Yes. Yes. Expired me when I go through my pantry and I'm just like, I bought this yesterday. Shit, why did that expire 2 years ago? It's the ADHD. Because you buy it when you're like, I'm obsessed with this thing. And then there's one day where you look at that thing and go, never. Nope. Nope. But then you had more because if you run out, then you don't want to have to run to the store in like the middle of the night because then you're not going to be able to sleep because you need the thing, right? Right. And then you're like, oops, what happened? Exactly, Maddie Flat. Maddie Flat's ADHD. A diva has distractions. Exactly. We're prepared. And then, item impermanence is a real thing too. Where you're like, oh shit, I didn't see that there, so it didn't exist. Facts. So this was May 5th, 2026. And then And then the court issued an order. Well, is this 2 orders? 2 orders. The court issued 2 orders. So let's look at the court's 2 orders. This order is from May 12th, 2026. The day before she's sentenced by the court. The day before sentencing, Judge M rules on the stay motion. Let's take a look at that first. Order granting motion to lift the stay on the petition to determine a disqualifying homicide. Now, before the court is the personal representative on the motion to lift the stay, which she filed April 2nd, 2026. No person or interested party opposed the motion. The time to do so has expired. Having considered the motion and applicable authorities, and for good cause appearing, the court grants the motion for the reasons stated in the motion. The stay on Katie's petition to determine disqualifying homicide is hereby lifted. Period. Which means this can now be heard. Serving Kouri Richins, Summit County Jail. Booking number, inmate number, address. We'll just serve this to you down the hall in jail. Here you go. And then he issued an order on the motion for summary judgment. Let's take a look at what Judge M has to say in this 16-page motion. Filed May 12th, 2026. Title: Order granting motion for summary judgment on petition to determine disqualifying homicide. He gave the same header. This was filed April 2nd. There was no response. Undisputed material facts. And the heading has a footnote. We get to footnote 1 in the heading. Footnote 1. Because no one filed an opposition, each material fact from the motion is deemed admitted. In addition, the court concludes that Katie supported each material fact in the motion with admissible record evidence. Kouri Richins married to decedent Eric Richins on June 15th, 2013. They remained married until Eric's death. Eric died on or about March 4th, 2022. Prior to his death, Eric worked with attorney Crystal Bowman Carter to formulate and execute a comprehensive estate plan. First, he signed that certain will of Eric Richins, and then they cited to the motion. The will names Kouri as Eric's wife, and it names Eric's 3 sons as his children. The will is a pour-over will, which operates to pour all of the estate's assets into a trust. So when the will is probated, everything that belongs to Eric literally just goes into the trust. The will is a pour-over will, takes all of Eric's assets into the trust. And this is what the estate and the trust are fighting over, is to claw back the things that Kouri diminished in other litigation. The will expressly devises everything in the estate to, quote, the then acting trustee of the trust. It then directs the trustee of the trust to administer the property according to the trust and any amendments made prior to Eric's death. All of the property goes to the trust. The trust has its marching orders. This is how you execute the trust. In the alternative, and only if the trust was not in effect at Eric's death, the will instructs the estate's PR to distribute the estate per capita at each generation. That's kind of the backup to the backup. Second, Eric signed the Eric Richins Living Trust Agreement Like the will, the trust agreement names Kouri as Eric's wife and names the children as his children. The trust agreement also names Eric's sons and Kouri as beneficiaries. Specifically, Kouri is the named beneficiary of the marital share of the marital share which the trustee was to fund into a Q-tip trust, literally spelled QTIP. We have gone over this in other things for today's purposes. We're not going to go through the marital share. There are laws in place that there are laws in place that the marital share needed to be funded and the amount that it needed to be funded to. So this was done lawfully, well, excluding Kouri from as much money as possible. They go on to say Eric's 3 sons are the named beneficiaries of the decedent's trust. Oh, so Kouri got a portioned off bit, her own little separate island, and the kids got the main share of the trust. The purpose of this trust really was to give Kouri what was legally, like the minimum legally required to be given to her, and everything else goes to the kids. It goes on to say, over the course of filing multiple criminal informations, the state of Utah charged Kouri with, among other things, aggravated murder, attempted aggravated murder, insurance fraud, and forgery. Authorities arrested Kouri in connection with Eric's murder May 8th, 2023. Just over 1 month later, the court held a hearing to consider Kouri's request for bail. At the close of evidence at the bail hearing, the court concluded that there was substantial evidence, that's in quotes, to support the aggravated murder charge, and it ordered that Kouri remain incarcerated while awaiting trial. Over the next few years, Kouri asked the court multiple times to reconsider its bail determination. She did. The court was disinclined to acquiesce to that request. The court says each time the court declined. In its second such ruling, the court specifically concluded that the body of evidence before it was, quote, sufficient to permit a reasonable jury to conclude that Kouri committed the offense charged of aggravated murder. On or about May 10th, 2023, Katie filed a petition to determine disqualifying homicide in the above captioned case. The petition seeks an order in judgment that Kouri committed the disqualifying homicide, and these are the bullet points we saw earlier, that Kouri forfeited all rights and benefits, that if Eric and Kouri owned any property as joint tenants, that joint tenancy is severed. Kouri is deemed to have predeceased Eric by operation of law. Kouri is deemed to have disclaimed any rights she may have otherwise under the will. You get nothing. From February 23rd, 2026 to March 16th, 2026, Kouri stood trial for the aggravated murder charge in connection with Eric's death. During trial, this court and a duly impaneled jury heard testimony from numerous witnesses, considered scores of exhibits. In relevant part, the court and jury heard and received evidence demonstrating the following. A. Kouri intentionally or knowingly caused Eric's death. B. Kouri caused Eric's death by administering to him a lethal dose of fentanyl. C. Kouri murdered Eric for pecuniary gain. Those are the aggravators. D. Kouri murdered Eric by administering a substance in a lethal amount, dosage, or quantity, namely fentanyl. At the close of the state's case, Kouri moved for a directed verdict. That was the argument we saw from Ramos. The same arguments we're going to see in their motion for new trial whenever it's filed. The court denied Kouri's motion, concluding that the state had presented a prima facie case against Kouri by producing believable evidence of each element of aggravated murder. All right, just because you disagree doesn't mean it's insufficient. After hearing closing arguments and deliberating, the jury convicted Kouri of aggravated murder in connection with Eric's death. Conclusions of law. Summary judgment is appropriate where there is no genuine dispute as to any material fact and the moving party is entitled to judgment as a matter of law. We saw this and covered it quite a bit in the TikTok Psychic case when we talked about summary judgment motions, but summary judgment motions are beyond a motion to dismiss. Remember, a motion to dismiss is early on in the proceedings, before discovery, and everything's taken in the light most favorable to the non-moving party. At summary judgment, that's a different standard because it has to be proven that there is no genuine dispute of law. And so there needs to be evidence shown there. The court goes on to say, through the motion, Katie seeks summary judgment on the petition. Specifically, she seeks an order concluding that Kouri committed a disqualifying homicide for the purposes of the Utah Slayer statute and determining the bullet points that we've now talked about a few times. The Slayer statute exists to ensure that a killer cannot profit from the killer's wrong. And that's directly quoted from the Utah Annotated Code. To that end, the Slayer statute strips anyone who committed a disqualifying homicide of any and all inheritance rights that they may have otherwise had as an heir or beneficiary of the victim. It causes them to forfeit any potential intestate share, elective share, omitted spouse's share, exempt property, or family allowance. It revokes any testamentary devices from the victim to the killer. It severs any interest that the killer and the victim held in joint tenancy, and it mandates that all provisions of the victim's estate plan operate as though the killer either disclaimed her rights or predeceased the victim. Everything operates as if you do not exist. Like, you do not go here, you do not exist. They treat it as if you are predeceased. A disqualifying homicide is any felony homicide offense described in Title 76, Chapter 5, for which the elements are established by preponderance of the evidence. Notice the difference? Preponderance of the evidence. That means that you could see a circumstance where somebody is not charged with a criminal homicide, but is still found to have committed a disqualifying homicide, because here the elements need to be established by a preponderance, not beyond a reasonable doubt. The court goes on to talk about the case law behind this. I'm going to just cover the footnote here where the court says essentially that aggravated murder is one of the homicide offenses. Footnote 2, this is the law of the case. In December 2023, the court concluded that an aggravated murder constitutes as a disqualifying homicide for purposes of the Slayer statute. Yes, yes. Specifically under Utah Code section, an actor commits an aggravated murder if the actor intentionally or knowingly causes the death of another individual under one of the enumerated circumstances. So special murder. And then the court enumerates those aggravators. We've talked about the aggravators, that murder plus. The court grants the motion for the following reasons. Well, jury got beyond a reasonable doubt. That means we've gotten ourselves to preponderance, which is a less burdensome burden than beyond a reasonable doubt. The court grants the motion for the following reasons. A jury found her guilty of murder. EDB summary. The court says a duly impaneled jury heard testimony and received evidence that Kouri 1 intended to cause Eric's death, 2 knowingly caused Eric's death, 3 caused Eric's death by administering a lethal amount of fentanyl, 4 caused Eric's death for monetary gain. With that evidence and after deliberation, the jury unanimously convicted Kouri of aggravated murder beyond a reasonable doubt. Period. The petition, which arose from and followed Kouri's criminal charges, seeks relief against Kouri for the criminal conduct underlying the offense, namely that Kouri is no longer an heir or beneficiary because she murdered Eric. Kouri's conviction shows that Kouri committed a disqualifying homicide. So, do you think Kouri read this before she was sentenced? The conviction has common law preclusive effect. You don't go here. We're not going to go through the common law. Judge M does a great job of going through the law. Again, the statute and the common law align on this. You cannot murder someone to inherit from them. You cannot expedite your inheritance. That is not permitted. The court goes through the case law, other decisions. I don't think this is deeply controversial. I can't imagine any states don't have common law on this fact. Issue preclusion applies here to the question of whether Kouri murdered Eric. Kouri already received the benefit of a robust criminal trial, one in which this court afforded her the utmost procedural safeguards. Yep. Sometimes too much. Only time I was critical of the judge. I was like, you are being very, very cautious. The court goes on to say there was a massive jury veneer. I am sure Judge M is right in pronouncing it veneery. I just literally cannot. My brain refuses. I hate it so much. It hurts my ears. The state provided and paid for a team of seasoned defense lawyers to represent Kouri. At least none of them have argued that they're unseasoned. At least we haven't ended up in full Ron territory. But Your Honor, I'm just a baby. I'm an unseasoned lawyer. I'm just a baby. Yeah, the state paid for a fleet of seasoned defense lawyers to represent Kouri. The state's murder claim, the predicate for a disqualifying homicide, was subject to the highest burden of proof that exists in our judicial system. And after 14 days of evidence and argument, a jury of Kouri's peers unanimously concluded that the state met its burden. I bet on jail calls she is motherfucking those juries up one side and down the other. I imagine that she is just having words for these are not her peers. Right? But that's beside, I digress. After 14 days of evidence and argument, a jury of Kouri's peers unanimously concluded that the state met its burden. None of these safeguards are going to be present here, or at least they will not be present to nearly the degree that they were in the criminal case. Thus, there is no risk of undue prejudice by applying the doctrine here, footnote 4. Restatement second of judgments. The court is essentially saying, look, the criminal case is the highest level of review that the facts in this case are going to get. So you're not going to get a higher level of review than a jury trial. The court goes on to talk about issue preclusion, saying that each element is satisfied. First, Kouri is a party to the criminal case. She's the named defendant, right? She's had these issues evaluated by another court. It is irrelevant that Katie was not a party to the criminal case. Issue preclusion applies so long as the party against whom the doctrine is asserted, in this case Kouri, was a party or in privity with a party to the prior adjudication. Where did we see issue preclusion last? That wasn't law school, because it doesn't come up all the time. We saw arguments regarding issue preclusion in Depp v. Heard. And one of the arguments with regard to issue preclusion in Depp v. Heard that was a substantial part of the argument was that Depp was not a party to the actions happening in England. So he was not a part of the UK actions. He was not a party to that. So he did not have the opportunity to defend himself, even though Heard's statements were evaluated in court there. There's also the issue of different systems, different countries, etc. But who was a party to the litigation was a part of that pretrial litigation that we covered a million years ago. Here, the court is illuminating that it does not matter that Katie was not the opposing party, because the doctrine to exclude somebody's rights to a thing is being leveraged against Kouri, and Kouri was a party. So it does not matter that the parties do not match up. Hopefully that makes sense. So the court is not evaluating arguments that Kouri made, because Kouri did not make any arguments. No one responded. But I think we've seen a history of Judge M going through each step of the law, even if the other side doesn't raise it. And he did that with the defense a couple times during trial. Even when they didn't raise an argument, he would raise those sua sponte and say, the law says this. It's not being argued. The law says this, but this, and this. So the court's evaluating, sometimes issue preclusion could come up here, doesn't apply here. So he is going through his checklist, even if it wasn't raised by the other side. I think now we are seeing a very Judge M level of thoroughness. And that's what you want from a judge. You want thoroughness. You want the judge to look at all options and answer them. And that's what he's doing. The court goes on to say, second, both the petition and the criminal case center on the same pivotal issue. An issue is identical where the parties or their privies litigated the issue in the first suit and or a determination on the issue was essential in resolving the first suit. The question is the same. Did Kouri murder Eric? Period. And that's what the court goes on to say. The central question is whether Kouri murdered Eric. The court concludes that the key issue in the petition, Eric's murder, is identical to the key issue in the criminal case. Third, Kouri fully and fairly litigated the issue of Eric's death. An issue is fully and fairly litigated when it is properly raised, submitted for determination, and actually determined. And the jury determined it. The criminal case, the court goes on to say, fully and fairly litigated the issue of Eric's murder. Kouri, with the assistance of counsel, litigated the state's murder allegations at a detention hearing, a preliminary hearing, motion practice, and through a 14-day jury trial. That proceeding afforded her significant procedural protections, the right to remain silent, for example, that she does not have here. Moreover, Kouri had, or should have had, more motivation to defend her position in the criminal case than she does here. Whereas this matter risks nothing more than potential monetary consequences, the criminal case implicates Kouri's fundamental liberty interest. In sum, the issue of Eric's death was litigated and decided. There was more at stake in the criminal case, and Kouri enjoyed more procedural safeguards than she will here. The court concludes that the third element is satisfied. So the court is now going through the issue preclusion and saying, hey, we can evaluate this. We can resolve these together because Kouri is not going to be cut off in her defense of herself. She's had every opportunity to defend herself in that other proceeding. The court goes on to say, they moved on to point 4, but the court, since we are not doing a law school treatise in issue preclusion, I'm jumping to the court's conclusion in these points. The jury's verdict is a substantive determination that Kouri committed a disqualifying homicide. Jurors considered hundreds of exhibits and testimony of over 40 witnesses. The court instructed the jurors on the applicable legal standards, including the elements necessary to prove that Kouri committed an aggravated murder. After receiving those instructions, the jury applied the relevant law to the evidence and rendered a verdict. The court concludes that their verdict is a, quote, judgment on the merits. Because all elements of issue preclusion are satisfied, the verdict in the criminal case is preclusive, that part. So the court went through how we get to the verdict in the criminal case being preclusive in the civil case. Kouri committed a disqualifying homicide and is barred from relitigating the cause of Eric's death here. Period. Period. You do not get to try to litigate again whether or not you murdered Eric. It is that issue is precluded, which means there's nothing really left to determine. The court goes on to say there is sufficient evidence to conclude by a preponderance of the evidence that Kouri committed a disqualifying homicide. Under the Slayer statute, the court can conclude that Kouri committed a disqualifying homicide so long as 1, Kouri's disinheritance would not create a manifest injustice, no injustice here, and 2, a preponderance of the evidence supports the court's conclusion. A jury verdict supports the court. Lyndon said, estoppel. Yes, we've reached the estoppel. You are estopped from arguing it. You don't get to do it again. Also, it would be fundamentally unjust for me. It would be fundamentally unjust to require the estate to continue to diminish their assets that are supposed to go to the children to relitigate an issue that has already been determined by a jury in a criminal trial. That would be the injustice. Not the court saying, a jury said you're guilty of murder, you're guilty of murder. So if a jury found it beyond a reasonable doubt, we can find it by a preponderance. Also, it's the same judge. In LA, this would be a nightmare. In LA, you'd be running around between courthouses and stuff. The result would be the same. It just wouldn't be as easy. The court here handles all cases, which is bananas to me, to have to go from criminal to civil to the rest of it. Drunken Prom Queen 17 said, does it not matter that she has the appeals process to consider? It doesn't matter for the purposes of summary judgment when the standard here is preponderance of the evidence because the evidence has been vetted. So anything that happens on appeal is not going to undo the court's preponderance of the evidence here because the standard is so much lower. There's no need to relitigate whether she committed a disqualifying homicide. So no, her appeals do not play in to this for them to go forward and be able to finally finish litigating the estate. And I think the court is going to go on to say the court has seen all the evidence and separately find a preponderance here. What would happen if she wins on appeal? Nothing. Because the court is going to go on to say, I think, what evidence the court sees that finds that there is a disqualifying homicide based on a preponderance. So the court's going to go ahead and evaluate the evidence separately here. So even if, which I think is unlikely, but even if something happened on appeal and she was granted a new trial, it wouldn't undo the court's finding. So let's see what the court goes on to say. First, a disinheritance would not result in manifest injustice. Although the Slayer statute does not expressly define the term manifest injustice, other areas of Utah law have long used the term. For instance, when evaluating what a term is meant for purposes of considering the propriety of criminal jury instructions, the Utah Supreme Court held that in most circumstances, the term manifest injustice is synonymous with the term plain error. The court concludes that manifest injustice for purposes of the Slayer statute has the same meaning as plain error review. Plain error review has three components. First, there must have been an error. Second, the error was obvious and should have been obvious to the district court. And third, the error was harmful. The court is going to go through that. We're going to skip over some of that. But the court concludes here that disinheriting Kouri will not be manifestly unjust. There is no appreciable risk of error in determining that Kouri committed a disqualifying homicide. That part. Even setting aside the preclusive effect of Kouri's conviction in the criminal case. For all of you that, Emily, fucking keep reading. Keep reading, Emily. Keep reading. Because the court's going to deal with it right here. The court is going to answer the question about what if appeal. This is the court's answer. Even setting aside the preclusive effect of Kouri's conviction in the criminal case, looking separate from the criminal case, quote, there is sufficient evidence to conclude by a preponderance that Kouri committed aggravated murder. Period. In addition, the court says there is no realistic probability at this point that Kouri will obtain anything better than a disinheritance. Even if Kouri inherited something from the estate or trust, Kouri has substantial financial debt. The estate also has a pending wrongful death claim against Kouri, which may yield a large money judgment. We haven't even begun to go through the wrongful death. Don't worry, we'll get there. But the court has said clearly, even aside from the jury verdict, there is a preponderance of the evidence here, which is a lower statute. This is a situation where Kouri could have been acquitted in criminal and still disinherited in civil. That result could absolutely happen. We saw it in the wrongful death case, in the O.J. Simpson case, I think most famously. You can be acquitted beyond a reasonable doubt and still found liable for wrongful death in civil. And that could have happened here too. It didn't, but it could have. The court goes on to say that when Kouri's debts and potential liabilities are balanced against the statutory elective share that she may have inherited but for the murder conviction, there's very little possibility Kouri would retain any portion of her potential inheritance. The court concludes that a disinheritance now will not result in error and will not deprive Kouri of a more favorable outcome later. The court's like, there's nothing. There's just nothing there. And there's not going to be anything there. There is a giant flaming hole, and you can throw money in it and catch it on fire, but there is nothing there. The court goes on to say, second, based on the jury's unanimous decision finding Kouri guilty beyond a reasonable doubt and the undisputed facts cited above, a reasonable fact finder could reach only one conclusion under the preponderance standard. Kouri committed a disqualifying homicide. For all of you who wanted the court's definition of preponderance in Utah, here we go. The preponderance standard, quote, requires the proponent of a contested fact to demonstrate that its existence is more likely than not. Preponderance. Meh. I'm sure that no one appreciates me referring to the preponderance standard as meh, more likely than not. Yeah, it's likely. Or stated differently, the court goes on to say a preponderance, quote, means the greater weight of the evidence, or, as sometimes stated, such degree of proof that the greater probability of truth lies therein. As a threshold matter, the court has made multiple prior rulings determining that there was sufficient evidence to conclude Kouri committed a disqualifying homicide. Here's the other part of that. The court is now going back to say that even before the jury verdict, the court found that there was enough evidence to hold her in custody and not grant bail. The court found that there was enough evidence at the probable cause determination, higher than your preponderance, at the probable cause determination at the preliminary hearing. So the court can now sidestep the ruling or sidestep the verdict and say, look, even at the preliminary hearing, the court found that there was probable cause. So even before we went to jury, there was enough there. And so the court's now backing up and showing the other places where the court found that there was sufficient evidence that would meet the preponderance standard. On June 12, 2023, the court concluded in the criminal case that there was substantial evidence to support the state's aggravated murder charge against Kouri. On December 7th, the court entered a preliminary injunction over Kouri's assets, concluding that Katie was, quote, substantially likely to prevail on the merits of the petition. The court froze the assets. On November 12th, 2024, the court concluded for a second time in the criminal case that there was substantial evidence to support the aggravated murder charge. On November 17th, 2025, the court concluded for a third time in the criminal case that there was substantial evidence to support the aggravated murder charge. Those were all the bail reconsiderations in the preliminary hearing, and then freezing the assets. While the evidence burdens at issue in those prior rulings were different from the preponderance standard, the evidence received at trial in the criminal case both confirms the court's prior rulings and is sufficient for the court to determine by a preponderance that Kouri committed a disqualifying homicide. And then the court goes on to reiterate what they said at the beginning, which is that the court received evidence proving all the elements of aggravated murder. Footnote 5. The motion extensively summarizes the evidence from trial in the criminal case that supports these elements. The court treats that summary as undisputed in accordance with Rule 56A4 and incorporates it herein by reference. So the court is taking the summary of the facts from the motion for summary judgment and saying, because those facts are undisputed, because Kouri didn't dispute them, those things are true. So there's no doubt that you committed, for this motion, this homicide. Let's see. The court goes on to say that that evidence was more than the greater weight of evidence showing that Kouri murdered Eric. Or, stated differently, based on the evidence, it is more likely than not that Kouri murdered Eric. That's the preponderance standard. As noted above, Kouri cannot challenge this conclusion. Period. Order. The motion is granted in full. The petition is granted in full. Kouri committed a disqualifying homicide for the purposes of Utah Code Section 75-2-803. Kouri consequently forfeited all rights and benefits she has or may have had with respect to the estate or trust, including an intestate share, an elective share, an omitted spouse's share, a homestead allowance, exempt property, or a family allowance. Any dispositions or appointments of property that Eric made to Kouri are hereby revoked. To the extent that Eric and Kouri held property as joint tenants, that joint tenancy is severed, and the ownership is deemed to be a tenancy in common. For purposes of determining Kouri's rights under any instrument that Eric executed, Kouri is deemed to have 1, disclaimed all rights, 2, predeceased Eric. Kouri cannot in any way profit by or from Eric's death. Period. Kouri cannot in any way profit by or from Eric's death. You get nothing. I mean, except for a prison stay. You got a prison stay. This came down the day before her sentencing. So, Northwest and many others asked, this order makes all the lawsuits moot. No, it doesn't make all the lawsuits moot. It makes some of the lawsuits moot. So, let's summarize this, and then let's talk about the other lawsuits. Under everything we've looked at in the civil context today, we get to the conclusion, the timing of this is just chef's kiss. But we get to the end of the estate order from Judge M, filed May 12th, 2026, the day before Kouri's sentencing, ordering on summary judgment that Kouri Richins is disinherited. You get nothing. You can take nothing under Eric's estate, and it settles the estate so that Eric's estate can finally be probated. That's all been frozen until now. So the estate can finally be probated. It can go into the trust, which means Kouri suing the trust and the estate over her share in the home and over the money that she put in to build a pool and whatever else, she forfeits all of it. So Kouri suing the estate is all going to be a bit moot. And I imagine we will see this filed in those cases and start to close them out. There are so many cases. However, the family is still, the estate is suing for wrongful death. That will still go forward because there will still be arguments there. I imagine there will be a motion for summary judgment in the wrongful death case as well. And in the lawsuit where the estate is suing Kouri and Kouri's mother, they are still trying to claw back some of the money that was dispersed in the year between Eric Richins dying and Kouri being arrested. That's going to still go forward. It cuts off a lot of the defenses from Kouri, but they're still trying to go after Kouri and mom to claw back money, and that litigation is still very much active and ongoing. So Kouri suing the estate is going to be closed out and moot because of this, because it doesn't matter. It doesn't matter. And she doesn't have a lawyer anyway, but it doesn't matter if she wins there. All of that, we have a rogue hair. All of that just becomes moot because she's disinherited. But in clawing back the money, well, that's still going to go forward. Remember, in that litigation, hold on, let me see if I can find it quickly. There are so many cases. Because again, there is an estate and a trust, and then these lawsuits to the estate and then to the trust, it's many. And then there's a business, I think there's a couple business lawsuits as well, but one of them is, well, we haven't even gotten to the business lawsuits. We haven't gotten to the wrongful death lawsuit. There are still a lot of ongoing lawsuits. However, the estate suing Kouri and Kouri's mother and the businesses are still going to go forward. Kouri's not going to have as many defenses there. Kouri doesn't have a lawyer there, but they are trying to claw back any money that was distributed. And in that case, let's just pull that up real quick, because trying to remember all of this is impossible in my brain. We are looking really briefly at the first amended complaint of the estate and trust suing Kouri, Kouri's mom, Kouri's brother, and Kouri's company. This is a quick summary of that. The estate and trust is seeking monetary damages of $300,000. And then when we went through this a while ago, we talked about money that was moved from Eric's mother's, I think, retirement account or life insurance. It might have been life insurance. We talked about the money from the business insurance. We talked about the money from the home and the overdrawing of the personal accounts and the HELOC and all of that. So we went through this a while ago, and it's been a minute. But at the end of the day, hold on, let's get to the end of the day. They're asking for over $300,000. I think that's helpful. But we went, oh God, I don't even remember when we went through this one. We'll find it and link it down below. But we went through the entirety of the litigation against Kouri, her mom, her brother. They are trying to find where these properties got distributed to, where the money got distributed to, and pull it back into the estate so it can go into the trust for the boys. So some of this litigation will keep going in trying to find where money has been distributed to. And that can include substitution of assets if money has come in. And I'm not, hear me now. I am not saying this has happened. I am saying it is not unknown to me that you would see a circumstance where even though Kouri can't profit off of an interview or social media or a news program using photos of her from when she was a child that are her property, that are her copyright, and, essentially licensing those to show on TV. It would not shock me if that money went to Kouri's mother or brother and not directly to Kouri. So if money from the estate was funneled out to mother and brother, and there are substitute assets there, the estate can go after them and try to claw them back. And I don't doubt for one solitary moment that Todd Gabler will be tenacious in trying to track down that money. Because that money would go back to the estate and go back into the trust for the boys. At the same time that we are seeing restitution being put out elsewhere, just in case Kouri ends up with money down the road. Because we don't know. Kouri's going to be in prison a long time. Maybe she'll get a job. I don't know what jobs they do in Utah prisons. Maybe she'll get a job in custody. And if she gets a job, that money can go to restitution, to the estate, to Chelsea Barney, and to others. But if anyone's going to find that money, I trust that Todd Gabler will. And that money can go back to where it's supposed to go if those orders are on the books, which is why they're going to start fighting all of this. Yes, very much. No, why don't you get a job? I was going full Offspring on that. WG, I hope that you were too. So, Cheryl said Todd works for the estate. Yes. Could Kouri declare bankruptcy? Not yet. And I don't think Kouri has the funds to litigate that successfully were she to try. So, where does this leave us? Well, it's going to pare down the civil litigation. It's not going to eliminate all of the civil litigation. It's going to extinguish some of Kouri's civil litigation. But Kouri is going to have to figure out whether or not she's going to represent herself. Ann Mullins in the chat said, when did Todd Gabler come aboard? Early on in this, with Kouri suing the estate. Lauren M said, I briefly worked in a bankruptcy law firm. It's more expensive than you think. It is. It can be incredibly expensive, and it's nuanced. And bankruptcy is not something that's just, easy to prepare. Though I wouldn't put it past Kouri to just stand in her cell and scream, I declare bankruptcy. I wouldn't. Who knows? She got a paralegal certificate in custody. That is not a knock to paralegals. I think one of the values with the paralegals is their work experience. And that is the part that Kouri is going to be missing. WG said, I'm all down with the Offspring. I was at USC at the same time as Dexter, but I don't think I ever ran into him. I saw that he gave a commencement address at USC. And even though we are a Bruin family, I love to see it. I love that Dexter does angel flights because he's also a pilot, because of course he is, because Dexter apparently has a time turner and more time in his life than the rest of us. Because he also uses his pilot's license and his plane to help transport people for medical need that can't afford transportation to where they need to get to for medical treatment, surgeries, etc. The more and more I learn about people, the cooler some of the stuff people do with their time is. And I love that he's like, I've got a plane. I can help transport people if they can't get to dialysis or to surgery or to what have you. I'll do it. And so he does private jet flights called angel flights to help people that have medical need and not the transportation that they need. He has I think he has 2 PhDs. I know one of them is in some type of molecular biology and one of them is in some kind of aerospace something. But I mean, the man has taken the time that he has to try to make the world around him better. And I appreciate it because it's nice to see. I think we summarized what was going on with Kouri well enough. I think that we will see, I was talking about Dexter Holland, lead singer for The Offspring. Sorry, chat. I just got so familiar. Look, the bands Emily has seen live a lot of times, Dave Matthews, number 1, The Offspring is number 2. Those are the bands I've been to the most concerts of. Emily, when are you going to get to see Dave Matthews this summer? I can't talk about it because the Cavaliers tour schedule and the Dave tour schedule are in a really tough alignment for me this summer. And it is causing all of the problems. But if I did not well summarize, not all of the civil stuff is done with Kouri, but the civil stuff that she initiated is going to be done because of this. And if you all permit me to be super nerdy, we're going to continue to follow what's going on with the estate, the trust, the wrongful death suit, which we haven't even gotten into yet, and we will, the wrongful death suit and more. So we will continue to follow the civil fallout. On Friday, we should have some more dates for the subsequent fraud prosecution. We'll see what happens with that case. Would I love for that case to go to trial? Yes. Yes. EDB is like, no, come get your girl. All of the prison. However, the realistic side of my brain, and the lawyer side of my brain, has to remind all of you that as much as a Bloodworth, Judge M, fraud trial take 2 is going to be one of my favorite things in the world, I understand that now that Kouri has been sentenced to life without the possibility of parole, the cost-benefit analysis of going to trial again may not lean towards the side of spending any more money on prosecuting Kouri Richins. So I am logically aware that that is a possibility, that they might resolve that case. I think that restitution for Chelsea Barney should be ordered. I don't know if they would be able to resolve that case for a plea deal. I don't know if Kouri would. I would like to see restitution ordered for Chelsea Barney just in case she can ever get that back at some point. But I don't know what will happen. Lara said recovery addict said he will send cameras. Oh, tell him to email me. I will help. I will help offset cost. If he wants to send cameras, I will do whatever I can to help because I want to know. I want to know. I'm here to help because that would be amazing. So, I don't know what they will choose to do. I'm curious. I am trying to not get my hopes up, but Doctor Who, this is exactly right. You can't get more than LWOP, correct? I want to see restitution. I don't think Kouri can pay it, but you never know. But she'll have new lawyers and she doesn't have those yet. So we've got a little bit of time where we can just fingers crossed and hope for more time in court with Judge M and Bloodworth, can't we? We can all just hope for a little more time in court with Judge M and Bloodworth. And they will be back. I think it's going to be everybody on just WebEx for Friday for a scheduling conference because they still need to schedule and I hope the court will have a ruling regarding the motion to embiggen time before that scheduling conference on Friday, but there will be a scheduling conference on Friday. The restitution hearing still needs to be scheduled. I hope to see the restitution hearing. I don't know when that'll be. We'll have to hear, there should be oral argument on the motion for new trial. So whenever those motions are done, that will get set and we'll see oral argument on the motion for new trial. Kouri will be going through the appellate process. She will get new appellate lawyers. We will see what happens with the appellate lawyers. And then we still have multiple civil litigations, including a business litigation we haven't even touched on yet. We'll get to wrongful death litigation, the estate suing Kouri, her mother, her brother, and them, and trying to claw back some of the money that Kouri was diminishing from the estate. So there is still a long way to go with this case, just in a different way. And now that we're all the way in. This is why I'm kind of picky when we get into cases, because we're going to be in it for a minute. That's just the reality of the situation. We're going to be in it for a minute. So, Say Something said, how many of those hearings will Kouri actually be present for? I mean, I would imagine they'd let her like WebEx in from the iPad in prison. So she'll have the right to watch in prison, but I don't think they're going to bring her in person. Maybe for the restitution hearing, they would transport her. I don't know how far away the prison is that she's housed in from Park City. Let's see. Where was she transferred? Utah Women's. I don't know how far that is. I mean, she's not out of state, and it might not be that far, but for the scheduling hearings and stuff, she'll just be on Zoom, essentially. Should we get to questions? We've got lots of questions. I've got lots of questions saved. You've got lots of questions. We've got lots of questions. So I imagine if we see Kouri back in court, it would be for the oral argument on the motion for new trial, maybe. And for the restitution hearing, maybe. But for everything else, she has the right to be there via screen. Then again, Utah allowed some of the jury voir dire to happen via WebEx. So they might determine that WebEx is a reasonable proximity and not transport her at all. So she might just be on WebEx the entire time. I imagine her attorneys would argue against that, but it's possible. So with all of that, it has been a very Utah Kouri day. You've got questions. I've still got lots of questions, but I think it's time to chat. We ready to chat? Let's chat. All right. Scheduling for the rest of the week. Make your cookies for Banfield's sentencing on Friday, because we're going to be in court in Virginia on Friday for Banfield's sentencing. I have not heard back from the court yet, but I hope to. I've not heard back from the court yet if the hearing on Thursday for Banfield has cameras. If it does, I'm covering the Banfield hearing on Thursday as well. But so we're going to wait and see. So we might be shuffling around the schedule a little bit. We're going to stream 3 times this week and go from there. Chloe J, I don't know if I'm going to cover yesterday's Taylor and Dakota hearing. I might just summarize it in the podcast. I'm not sure yet. There's a lot of things going on, and my ADHD brain is just like, bing, 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 bing. I'm trying not to jump into a new thing without closing out the old thing. Moo Boy Moo, good to see you in the chat. Question, did we ever figure out the story about Bryce's pants? No. However, I want answers. I know y'all want answers. We're going to try to find a way to have answers. So don't worry. We will look for a way to have answers. Let's see. Primetime, KCL. I do not know these trials. I do not know this case. I will not be available in August, but we'll see about September. I will not be available in August. So if anything is going to trial in August, that doesn't mean we won't cover it later. Sometimes we do that. I don't know the case. But in August, I am going to be in Indiana, in Indianapolis. I'm going to be moving. I'm going to be collecting my child from DCI and immediately depositing him to trial. Not to trial. We're in trial. We're not in trial. To college, like within 24 hours. So it is going to be a collect from finals take to college. So I am going to be, I don't know what I'm going to do in August. I'm already stressed. The logistics of the thing are going to be spicy. Yeah. We have spicy logistics, but we have to, yes. So I am trying to adequately set expectations for what my August is going to look like. And DCI finals are a lot of days, and I'm just going to be in DCI world. I'm going to run away and be in band land for the entirety of DCI finals. I cannot wait. I ran into so many of y'all last year. It was so much fun. And DCI finals are inside and Lucas Oil's air conditioned. It's so good. I'm so happy about that. I am so happy about that. And I love getting to see him perform that many days in a row as we get to the end of DCI. I love getting to see all of the cores perform. I love running into y'all. I love running into the people that I've met through band and through core. And there are performers that Travis marched with in high school that are in DCI. There are members of the Cavaliers, that I watched perform last year that I cannot wait to see again. There are some age outs that are just incredible performers. I have all of the thoughts and feelings. So it is getting into band season for me. No August trials, but we also have some trials that we might be coming back to at the end of August that I am eagerly awaiting and have been eagerly awaiting. So I've been eagerly awaiting the Keefe D case. We'll see when that goes to trial. There are some motions that are starting to happen. So the Keefe D trial for the death of Tupac is starting to pick back up again. It's been slow, but it's starting to pick back up again. And I am keeping an eye on that. That might be a coverage on delay, but we are going to cover that whenever it goes to trial, because it's going to be going to trial. But lawyers keep switching and there's more motions happening, and lawyers just changed in March. So there hasn't been a lot happening in that case, but it will be going to trial. So it might be delay, but we will cover it, even if it's on delay. So I will be keeping an eye for Judge M's ruling. I am on the motion to extend time, but the defense has like 3 days to file a reply. So it's not ready for order yet. So we'll see what the defense reply is, if they file a reply or not. And then we'll go from there. But I will keep an eye on the case that you guys just asked me to cover. So on other cases, we will be picking up more new stuff in the fall, because we will be picking up more new stuff in the fall. I am very invested at this point in the Sharilla appeal. I am in. The second the defense was like, but Your Honor, it's a leap year, I was like, the fuck is happening? The fuck is happening? What do you mean? What do you mean? But Your Honor, it's a leap year. What do you mean, but Your Honor, it's a leap year? I'm invested. I want to see what the Ohio Supreme Court does. I want to go back and cover, if you guys are interested, I want to go back and cover the underlying motion for post-judgment relief. We have not covered that yet. We've not covered what's brewing under the surface that they might not have heard because they didn't file it in time. I'm fascinated. I'm fascinated. I'm fascinated. So thank you, Law Nerds. It's great to see all of your member chats. I see them, even if I don't get all of them pulled up, I do see them when we're back here. Same said, what is Kouri up to now? Losing in the civil case. So there's that. Michelle, we definitely talked about how the cats are doing a little bit earlier. Good to see all of the Law Nerds. I love getting to see all of your chats. It's been just a minute. Butterfly Mama said, have you checked your emails? My team handles all of the email, or Emily would never get anything done, but team has emails. Botanist, I have seen 1,000 of you ask about this. The bricks and minifigs. Let me ask y'all, because I was getting texts about this yesterday too. Is there a legal component to this? Because other than people asking about this, I do not know yet. Is there a legal case? Is there law to help? Let me know. Is there law to be explained? A lot of you are saying there should be. Do we want to put it up to a vote? We can put it up to a vote. It might not be this week, but we can put it up to a vote. Motion to cover the bricks and minifigs chicanery. I can put it up to a vote, but if there are not court filings, it's going to be difficult. A quick rundown. I don't know enough to give a quick rundown other than people keep asking me about it. But it seems like, and again, this is the quickest rundown because I have been asked about it quite a bit. The quickest rundown I can give is that it seems that there was a consignment agreement, and then the Lego sets that were consigned to a store, the store changed ownership, and then the wheels came off, and they were not honoring the consignment agreement, and then shit popped off. I don't know when it popped off, but it seems like it is a story that has been popping off on YouTube first, and then has just started to like breach YouTube containment. I will look and see if I can find court filings. If you guys are interested, I'll put up polls and see if we can find court filings on it, because I have seen a lot of you ask when I'm getting texts about people asking, have you heard of this? And when I have started getting a lot of questions from y'all about it, I will take a look. However, if I'm going to take a look, I'm going to take a look at the court documents and not all of the other stuff, which can be hard if this is something that's popping off outside of court, because the outside of court stuff is not what I cover. So I've got to take a look and see if there is inside of court stuff. So I'll see what I can find. But outside of court stuff is not something I can help with as much. So what's my answer? I will look. I will look. I've been asked a lot. I cannot promise that will be this week, but I will look and see what I can find in court, because the outside of court stuff doesn't give us a lot of help. Let's see. The Lauren said, I'm so sad for Murdaugh number 2. HD Nerd Life, EDB, did you see about the bricks and minifigs fiasco? Other than being asked about it, I have not seen anything about it, but I do have to disclose that when I take time off, I am generally like off in the, I'm not looking at anything. I'm not keeping up with what's going on with cases. I'm not doing any of it. Griffin and I have been doing a Myrtle puzzle that we started during graduation. I have been actually building some Legos because like the flowers back there are Lego. I love the Lego flowers. We have been doing garden projects. We have been doing house projects. I have decided that I hate the way everything is organized in my closet. We had to rearrange office storage when my parents were visiting. So when I am offline, I'm like, pop on an Audible book. I re-listen to the Empyrean series and do all the other stuff because it is the only way to actually feel like I have downtime, because there is so much going on online all the time that I find the need to just be like, nope. So no, this all popped off while I was, I think this all popped off while I was basically logged off to focus on all the other things. And I find that type of a break really restorative. But then sometimes when I come back, it's like, girl, did you see? I'm like, no, I didn't. And I had gotten questions about the crash as well. I had gotten texts about the crash and I'm like, what's going on with that? Which is why I talked about it in the podcast. But I had not seen the social media chatter about it because I've really not been much on social media since graduation. And at graduation, I saw a bunch of the videos and photos of other high schools in my area getting soaked during graduation and was like, oh, wow. I was like, Travis, how are your friends at this school, that school, and the rest of it? And he was like, wet, but fine. I was like, all right. So we had our own stuff, and we had all the end of year stuff at Griffin's school and the end of year stuff for Travis all overlapped. So I can tell you a lot about not internet things at the moment from the last few weeks. So that's kind of where I'm at. Ex-Dark Student said, Murdaugh was the first stream of EDB I watched. Feel like I have come full circle. Yeah, the fact that we are getting, I think this is our first case that we've covered that's been overturned on appeal and is going to get a retrial. Like, we've covered retrials in Karen Reed. We have covered multiple trials in front of the same judge. But this one is a new circle back. Heretic Investments senior interview in a recent Karen Reed doc. No, that's going to be Kouri Richins documentary, I think. Some of you say you saw me in a Murdaugh thing. I have no idea what that is, but I'll find it. But I did give interviews with ABC during trial with regard to Kouri Richins. Thank you, Lisa, for the gift of memberships. Thank you to everyone who gifted memberships. I appreciate it. Lisa also said, I got my tote bag shirt and lanyard. Love them. Yay. Thank you, Law Nerds, for helping me earlier figure out the days. Corey said, turning in homework at 11:59:59, worked in school. Yeah, the appellate court was like, no. It was the Netflix Murdaugh unconvicted. I'll have to go look. Because there have been times, Netflix in particular has used stuff from YouTube without letting me know. So there's been that, which is great. We always love that, but I'll go look for it because I had no idea. So Carrie said, I thought Judge M said initially, I'm not unsympathetic, but you have two other highly qualified attorneys available. So does this warrant a delay? That, I think, was regarding the continuance on the sentencing, if I remember correctly. I think so. Wouldn't be too mad if the defense was making a compilation of Bloodworth facing. That'd be funny. They can't really. Bloodworth was pretty stoic during trial. There were moments, there were peaks, but pretty composed during trial. Corey's face got wilder as the trial went on. So there was that. Didn't they do a video edit and trial like overnight? They might have. But I don't remember. Emily's Life on Wheels says, why would they need to edit any videos? I don't know. Wouldn't they just keep them as they are for completeness and context? I don't know what they would need to edit, truly, because the motion for new trial is stuff that happened in trial. So I don't know. Sweet Baby Ray said, can you read Duggar's pro se motion to vacate and strike? I will pull it. I don't know. I imagine we're talking about Josh, because I know there's stuff going on with other Duggars. I will take a look and see. That also might be a podcast topic. But I'll take a look and see, because we love Judge Sass, and we covered some of the sentencing on that Ice Baby. We've chatted about that. Yes, we have. Ashley said, I hope everyone has a wonderful June. Happy to be a law nerd for a whole 66 months. It's my favorite place to be. EDB, you make me laugh, because same. It's amazing. And we're here. We get to just do all of the things. Please drop the deets of the water bottle you were using for infusions, please and thank you. This is an old water bottle that is just glass. So it's, I think, Corksicle that I got a few years ago. And I like using glass. If I'm going to put like mint and stuff in it, I think, how big is it? I don't know. I cannot see the bottom of this. I think it's 20 ounces, but I didn't have any clean ball jars or mason jars. I didn't have a clean jar. This will probably go in a clean jar when I have one, but they've all been used for other stuff. So that's what I would generally do. So Emily's Life on Wheels says, can we have your cool law nerd calendar? What you made sounds so awesome. I don't know about that. I will have to think about whether we can figure out a way to do a version of it, because it has a lot of the inside thoughts in my docket, but I will think about what we can do. We have been rolling out a sample docket, and are trying to find a way to calendar things. The difficulty I have in calendaring things is that stuff shifts, and I always feel bad when it's like, but you said we were doing this today. And I'm like, right, but then this other thing happened and now we're shifting the schedule. And there are things on the docket that are things that I am just thinking of that don't always come to fruition, but we are working on a way to bring a little bit more of a docket and a heads up of what we're doing, but also leave the flexibility that I need, because otherwise I feel stuck. If it's like, but I told everybody we were doing this, but then we need to shift. So some of it is a me thing, but also it can be hard to shift course if I've already told, hundreds of thousands of y'all that we're doing XYZ, and then I shift, and then I come into chat and everybody's like, wait, but I thought we were doing, I know. But you said we were going to do today. I know. We had to shift. And sometimes we have to shift. So I will see what we can do. Right now, we are looking at a week by week of this is what we're covering this week. This is what we're streaming. And for the summer, that's probably going to work best for me as things are dynamic. And there is travel that is just going to upend all of it. But yeah, we need a Google Cal at some point, probably for streams and updates. But that's what we have the app for, to keep you guys posted. All right, let's see. San, I hope I said that correctly. Gifted 10 memberships. Thank you for the 10 gifted memberships. Auntie Weed said, just dropped my daughter off in Iowa so she can march with the Blue Stars for the first time. Congratulations. I think there are so many teams that start with blue. Congratulations. Have the best time. If I can impart any unsolicited advice, Houston is the hottest venue that we went to basically all summer. It was so hot. San Antonio is indoors and air conditioned finals are indoors and air conditioned. Also, if you want to go to finals, make the plans for that now, because if you wait, it will become more difficult. So just make the plans for finals now, and good luck to your daughter. I hope that she has an absolutely amazing season. I can't wait to see what they put on the field this year. And please don't be mad when the Cavaliers scores higher than them. It's just, we're all friends here, Law Nerds. We're all friends. But they often perform around the same time as each other. And so that's going to be fantastic. Soft Cheeks says, I marched 6 seasons of drum corps. Avoid Houston. Wait a sec. Soft Cheeks, did you just 6 seasons? 6 seasons. I mean, not everybody even gets to 5. 6 seasons is impressive and insane and amazing. And congratulations. 6 seasons is wild and amazing. Also, if you want to share which corps, you're welcome to, but you don't have to, but you can let us know. We have lots of corps friends in here. We have law nerds that have marched with just about every corps you can name, and some that no longer exist because, you know, it's the thing. But Houston is tough. Like Houston is tough. Houston is tough. I have not been to Allentown yet. Anthony said I marched. ACP said I marched 2 seasons and I'm still tired. That's so fair. It's so fair. Absolutely fair. So it's, yeah. My friends marched and I'm still tired. My kid marched and I'm still tired. But it's such a cool thing to be a part of. And I absolutely enjoy it. Soft Cheeks said 2 at Academy, 4 at Santa Clara, 1 drums in 2014. Vanguard is fantastic. Absolutely. I know Academy not as well, know Vanguard better. Absolutely, just it's a fantastic experience, but I love it. A number of you in the chat are saying that the pinned post has finally hit the bottom of your account. I'm so sorry. I hate it. And we're trying, but I hate it too. I hate it too. JT Law said, saw water polo LAC 28 is in LBC, Lawnerd Olympic meetup. Well, at least we've got plenty of time to plan. You never know. I need them to just let me announce water polo, because it would be amazing. It would be amazing. It would be so good. Silja the Knitting Baker, thank you, Emily, for keeping me company while I bake for tomorrow, my 40th birthday. P.S. It's 10:50 p.m. over here and still not done. Oh, that sounds like me. Happy early birthday. Happy 40th. 40 is amazing. Enjoy it. And I am sure that everyone is going to enjoy all of the baking. It's so good. Angie English, congrats to T on graduating a DCI season. Hope you all have the best time. I know you were in all the feels. I'm still in all the feels. I am still in all the feels. It's okay. We're fine. Everything's fine. It's good. I am all of the feels, but they're mine. Because, thankfully, I've gotten to see, because Cavaliers has posted, and Law Nerds, by the way, as we wrap up today, can we just say that y'all are so incredibly supportive. There were posts of tea on, I think, Cavaliers Guard and the Cavaliers page that I saw because you guys had gone and put purple hearts on it. I am so incredibly touched, and I am just so appreciative of the just really enthusiastic cheering on of the internet aunties and uncles, just cheering on T and being like, we're cheering, the Lawners are cheering you on from here. T doesn't mind. He absolutely He loves it. We ran into law nerds during our travels in the airport. I am sure I looked like I was just sitting there going, we ran into law nerds during our travels to get Travis to spring training at the end of May, because it was just wild. And it was so lovely to run into you guys. And every time we've run into you, whether it's just me or the family, my family is always delighted to meet the law nerds. And Travis was like, it's always so funny to just see you with the law nerds. I'm like, I know, because I'm mom, but also law nerds. And then a marcher from another corps recognized Travis in the airport and started talking to him. I'm like, right, sir. He's like, I mean, I'm wearing a Cavaliers jacket. I'm like, but still, you are also now in a like world stage performing art where you have built this network of other performers that also know who you are. And I love it. So it's not just me. So it's really great to see. And there are times that you guys see it before even I do. But one of the things that makes it a little easier on my heart, one, I have definitely overcompensated by buying plants. It's just what it is. And two, seeing just the genuine joy on his face in the photos and the shares that are coming out of spring camp, because he does not share on social a lot at all, is lovely for me to see. And then he's been great about keeping in touch. And I don't think the Cavaliers mind the Purple Hearts at all, because everybody else floods their comment section with dunks. So it's fine that the law nerds get to balance it out. And I absolutely love it. You guys have been just incredibly supportive, and it's so fun. So Travis believes that you are a YouTuber. Well, he knows that I make YouTube videos. Griffin is a little bit more of the needling me about it variety. But he reminds me that there are parents at his school and at Travis's school that are way more famous than I am, which is true. And I just tease him. I'm like, there are law nerds. I just have a really big community. It's not famous. It's just we have a big community, and it's amazing. I mean, it's not quite the same as people who are on like football stadium tours for the summer. It's not quite that. However, I have run into law nerds at Griffin's school as well. And I'm like, whatever, Griffin. So it's been fun, but seeing T just excited for camp and having a great time with his corps has eased my heart just a little bit, even though I'm also nerve-sighted for him about the stress of an entire marching summer on tour and then a one-day turnaround to college. I'm stressed. He's less stressed. He's like, it's fine. I'm like, oh my God. But you know what? We live in a beautiful age of not being just stuck in the middle of nowhere for college and being able to not get anything unless you're like phone ordering it from the LL Bean catalog. So ultimately, it's going to be fine. It's going to be fine. He will be fine. I will be fine. It will be fine. It will all be fine. The logistics of it are going to be a thing, but it will be fine. And when I get to go to, Indianapolis, there's a Kouri, because somehow there is not a Kouri in Tennessee. There is one near Atlanta, outside Atlanta, and there is one in Indianapolis. So I get to go eat all of the delicious Kouri sushi that I love. So I'm very excited. But we have a lot of logistics this summer, and it's going to be fine. It's all going to be fine. So, law nerds, I will see you either tomorrow or Thursday. I am not sure yet. I am sorry that I am not sure yet. I am not sure yet. I'm going to see what's going on with with Banfield's motion for new trial hearing on Thursday. If we have access to that, I would really like to stream that with you guys on Thursday and then stream sentencing Friday. If there is not going to be a camera for that, we might still just stream on Thursday and stream something else and then stream sentencing on Friday. So we're going to do 3 this summer. So with all of that, random person, we used these when we moved houses, like each time we've moved houses. We love them. They are the greatest things ever created. Yes, we have a bunch of them. They're so good. So with that, Law Nerds, I will see you soon. And Mad Marcia, where do you get the IKEA handlebags from? I think you can order directly from the IKEA website. There are dupes all over the place on Amazon. I trust the IKEA ones. They're so good. They're so good. And I think you can probably just order them online from IKEA, unless you have an IKEA close by, and then you can get meatballs and giant IKEA handlebags. They're fantastic. But actually, if we go to the IKEA in Atlanta, we can also go to Kouri. So there's that. All right, Law Nerds, you are the best. I will keep you updated later today in the app. I will send out just a message to let you know what I'm thinking for schedule, if we're going to stream Wednesday or Thursday. It might make sense. I need to just talk to Team Baker. It might make sense just to plan Thursday. And if we have a hearing, we do. And if we don't, we cover all the other things going on. And that might be the easiest way to do it. And then Friday, of course, get your cookies ready. Get your cookies ready because we're going to have a Banfield sentencing. I'll be in Houston and San Antonio. Houston is so hot. Houston is so hot. I will be in Houston. I will be bright. This color red. I am heat sensitive. She is meant for cooler climates. I will be this color. I will be that color red, but I will be there. Because, well, you know, it's so close to San Antonio. And if I just go to San Antonio, then I feel bad that I'm not in Houston. I guess we could shift it and go to San Antonio and then Dallas, but this year, Houston, then San Antonio. We'll see what happens next year. Law Nerds, you are the best. I will see you soon. It's always good chatting with you. Can you believe all the Kouri Richins shit? Can you believe this? I can. I love it. I love it. And I will see you guys. Well, I'll see you soon. I will see you soon. Have a good one, Law Nerds. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.